Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not...
Hello, grand jury.
Hello, and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
We're getting commentary on the case.
Literally not true.
Dati mihi Anglican for each verbal flooding. I didn't ask you to interrupt me.
Is that correct?
Oh, for crumb's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. It's a Monday, and it sure feels like it.
Hello.
May just sort of crept up on me somehow. It snuck up on me. And here we are already on Star Wars Day, May the 4th, and may the 4th be with you. All right, good morning, welcome, happy Star Wars Day, and 81st anniversary to the liberation of Denmark. You chose Star Wars Day to liberate Denmark? That is awesome. Well, I guess if I do the math, 81 years ago, yes, Star Wars came after. All right, let's turn the music down a little bit. Pre-trial. Let's see. Fran Fitzgerald, congratulations, you were first in chat this Monday morning. Apparently you had a great weekend. Your Monday may not be so great. Everything IP related worldwide, it's your responsibility. Yes, we are punishing you for your promptness. Congratulations, Fran. You figured out how to hack the system and mod chat on screen. Okay, Greeners. Sending zombie pictures to mod chat. It's all good. How's everybody doing? Good morning. I'm hoping to catch a little bit of a live stream here in just a second before they delete it, where I've heard a lot of excuses for tickets, but not this one before. And anyway, we'll catch that in just a minute. We need a legit trial soon, as opposed to all these fake trials where people don't actually face prison time or tickets, right? Sorry, Posty 7. Legit trial. By legit trial, you mean a long trial? Or, I mean, I can only think of one actual court case we watched that was a prank in the last 4 years. Tell me more about what sort of trial you're looking for. Today we're looking at a double murder. I think that's fairly legit. That's out of Judge Boyd's courtroom. We're trying to jump to around lunchtime in just a couple hours. Are you saying you don't like the pretrial stuff, or you don't like smaller trials? Let me know. I'm here to serve. Let's see. We've got birthdays this morning. Thank you very much, Greeners. You drew the short straw this morning. I think what was it? The person who would watch the least Star Wars films had to do this, but then Thomas bailed and he went golfing, so you had to take over for him. Happy birthday to Jennifer, Pam Jams, Shannon Lane, Shelbster, Speedy, and then we had Jacob, Kathy, and Snow Leopard today, I believe. So Jennifer, Pam Jams, Shannon Lane, Shelbster, and Speedy are today. I think Jacob, Kathy, and Snow Leopard were yesterday. That's sort of how it works in my head. If I got that backwards, I apologize. But join with me. We're going to try to sing to all these people in, I don't know, 1, maybe 2 verses. Everyone, if you're able and it's legal, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. We're warmed up and ready. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Jennifer, Pam Jam, Shannon, Elaine, Shelbster, and Speedy. Happy birthday to you. We'll add Jordan on this next verse. Thank you, Greeners, for that one. Make it pop, dancers. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Jacob, Jordan, Kathy, and Snow Leopard X. Happy birthday to you. Is Snow Leopard X, is that actually Snow Leopard, or is that like, are we celebrating a Mac OS version? Let me know. To everyone who's celebrating their birthdays today, happy birthday. I realize there are many wonderful days, but today is your special day, and there are a million places you could be, and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy is ours. Hopefully you can turn that joy back to you, make your day just a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, Bob Evans, and Cracker Barrel. I actually added Jordan right after the other J. Verse 2, we sang it. Jordan, you're covered. Happy birthday, Jordan. We added you after Jacob, if you go back on the replay. Check me on that. Jacob, Jordan, Kathy, Leopard X, right? I alphabetized. I did. That's wonderful. And Josh, if you were singing along, you would know. Yeah, I'm just saying. Happy Monday, everybody. Happy birthday. Help yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, Bob Evans, and Cracker Barrel. Did I say that part already? Now I forgot if I did the pancakes are like the most important part. The name is number 1, and then pancakes is number 2. So, all right, happy birthday. Drum solo for the big finish, ready? Beautiful. How are y'all doing this morning?
Happy birthday.
It is a Monday.
You look good.
A couple of you are a little hungover, I think. Ninnis, I'm looking at you. The music seems a little loud this morning. It's not us. I'm just saying, it's not us. Welcome. Let me tell you, this will put a smile on your face, or you'll turn red with embarrassment, as I did. Let me tell you what I did over the weekend. My wife, as part of her, she's a volunteer assistant that helps people get through college classes and admitted in college and works with them as they get going. It's a really cool job. It's really awesome. It's not a job, it's volunteer. But she helps these teams of people and works with them for like 21 weeks and gets them up and going. So she's in a meeting over the weekend, a Zoom meeting with, I don't know, there's like maybe 30 other people on the Zoom. And she's set up. She's sitting on the couch. She's using one of our like lamp stands to set the iPad on so she doesn't have to hold it. And so it just catches her. It's afternoon. The sun's streaming in through the window, so she's well lit. And it was perfect. And I'm thinking, as you married folk, you might relate to this. I think, it would be funny to prank her a little bit because while she's on Zoom and has to look all proper and smiley and nodding and paying attention, the Zoom people don't know what's happening behind the camera. So I can't believe I'm demonstrating this. Oh my goodness. Okay. I'm thinking better of the story now. So I walked into the room and stood directly behind the camera in her field of view. And I did something like that. Okay? Something like that. Very close to that, as a matter of fact. Extreme. That was almost the exact thing. And clipped, yeah. And she promptly mutes herself on Zoom and says, you're backlit, meaning that her background, which was the living room wall with nothing on it, was a perfect portrait from my shadow, which appeared right over her. So what was meant for just her was shared by the class. So that's how my weekend went. How did you guys do? I haven't talked to any of them, or she hasn't since then. I don't know what happened other than that. So anyway, add to that, on Saturday we went car shopping because we sold our one car, our Chip, that we bought like 7 years ago. And there's no shame in that.
Shame on you, sir.
There's no shame. We sold our one car and we drove I'll say it. We drove 3 hours to go car shopping, to go test drive a car, which the lady described as basically the bee's knees. It was a Lexus. She's like leather, all-wheel drive. It's sunroof, moonroof, all the options. It has navigation, and the pictures were limited, and the price was great. And we drove all the way to this place and met her in an Aldi parking lot, which was our first. There was our first clue. And we didn't see her. I mean, we saw some lady standing next to a dumpy old car, but we didn't see her. And then we're like, we're here. She's like, I'm here. I'm right by the entrance. I'm like, it couldn't be her, right? That wouldn't be. It was. I will tell you, I got in and I drove that car against my better judgment. She would not stop talking the entire time I was driving. I mean, it was like nonstop, 100 miles an hour about how great her car was and how the price was so low and that next week she was going to raise it $1,000 if it didn't sell. And how the brakes, even though they're grinding right now, she has new rotors and pads and she would include those for free. And she always uses only Lexus parts, original OEM, even though these ones were different because she bought them online. And it's just going on and on. And I will describe the car interior like this. Yes, it had navigation. If by navigation you mean some Temu large screen glued to the dash that takes over about a third of your view. And it's like, it covers everything from like dash to rear view mirror. Just a big old screen, and like part of it is a map. It was terrible. And the interior of the car was covered in a fine mist of syrup. Just everything was sticky. Just like you grabbed the wheel and it grabbed you back. And so the price is like great, right? This was like well below what we wanted to spend. And Miss RA is all excited. She's like, okay, my turn to drive. I'm like, nope, we're done. I give her we've got a special tap. I'm like, I walk behind her and I give her a little tap on the waist, guys, on the waist. And that's the clue. It's like, we're done. And so she's like, well, call me when you decide this is the one you want. And I'm like, yeah, don't wait by the phone.
This is not Burger King. People do not get to have it their way.
We drove 15 minutes to a car dealership that had 200 used cars on the lot. And for some reason, this dealership was like targeted at our price range. So we could have purchased like 90% of the cars on the lot because they're all budget. And this guy, we walk in, he's like, hey, just park wherever, and there's like no parking. We're like squeezing through. It looks like it's junkyard parking. The cars are just crammed in there. And so we parked wherever, and he's like, all the cars are locked. Just take a look, whatever. If you want to drive them, let me know. And we found, another Lexus, just like the one we had just driven to compare it to. And he's like, hey, let me get you the keys. Just pull it up. He threw the keys to me. He's like, just pull it up here. I'll get you a plate. Threw it up, and we drove up there. He handed me the keys and the plate. I'm like, do you need my driver's license or see my insurance? No, you're good. I'm like, all right. So I took it for a test drive. It was crap. Brought it back, and we're like, well, we're looking at these three vehicles. And he's like, let me give you the keys. He gives us 3 sets of keys. He's like, test drive them, whatever. You're fine. And so we're just driving around. It's like a very trusting guy. Anyway, long story short, 11 hours of car shopping, and we still didn't buy a car. So we have another day of car shopping ahead of us. Anyway, good morning. Hope your Monday is doing great. I'm sorry, it was so miserable. It sucked. You guys, I hate car shopping. Y'all look honest. Yeah, I think he was wanting them to be stolen. Like the insurance value was worth more than what he had vested in them. That's like it must be his business model. But we did figure out that the license plate had duct taped to the back of it, an air tag. So at least he could get his plate back if he wanted it. So, it was all good. All right. By the way, the first car, the lady's like, it's in excellent condition. It looks like somebody took a ball peen hammer, like the small end, and just went to town on one door. And it almost like punctured the metal. Like you could hide a good shooter marble in the dent that it had on the. I'm like, how is this good condition? Why are you priced at high dealer cost on this? And yeah, anyway. I went to CarMax. It's last car story, I swear. Last car story. went to CarMax, which apparently their model is, if we make you fill out enough paperwork before you ever get to see a vehicle, you'll just give up and buy it. So half an hour filling out paperwork to test drive a vehicle. My wife did that on Saturday. We came back on Monday because the guy says, come back on Monday. You can only drive 2 a day, by the way. You only get 2 choices. We have 100,000 cars on a lot. You can only drive 2 of them. So she drove 2 on Saturday. He says, come back on Monday, ask for me. We'll let you drive this other one. We came back on Monday. We walk in and they're like, he's not here. Your guy, Jordan's not here, or Joe, or whatever his name was. I'm like, well, good. Well, he told us to come back so we could drive the car. Did you have an appointment? I'm like, we don't do appointments. Do you have cars you want to sell? Because I'm a customer and I'm looking to buy a car. And the guys, I got a little too snarky with him, and we had to leave. Not that they told us to leave and said we couldn't come back. That didn't happen, but we were very close. Anyway. All right. It's so good to be back at work, not car shopping. Let's do a quick little worst excuse ever moment. If you guys will bear with me, let's see if we can get this to fly here. Let's play. This is going to be on 7, right? On 7, yes. Yes, that's it. Take 7. Where's 7? Judge, you there? Who's next? Worst excuse ever. Staring at it's not going to change it. Just call the name, Judge.
The court calls case number 26RO01744 and 44A. These are People versus Dylan Matthew Weldon. That's you, sir?
Yes, sir.
Mr. Weldon, you were present a few minutes ago when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court to instruct that you must select from one of 3 options to protect your own rights, correct?
Yes.
Thank you, Mr. Weldon. The citation before the court was issued on March 28 of this year at about 11:15 in the evening. You were operating a 2007 Chevrolet, white in color, on Woodward Avenue, M1 Avenue, Coolidge Highway, City of Royal Oak. And at that place and time, you were cited for expired plates. The vehicle plate had expired on October 1st of last year. You were cited for disobeyed traffic control device in as much as you failed to fully stop for a stop sign. And there's a warning that's not before the court today. So those are the 2 matters before the court.
Put your worst guess in chat right now.
You can admit and explain, or you can deny responsibility. And the court will swear the parties and take the testimony. What do you wish the court to do for you?
I'll admit guilty with an explanation.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak with an expired tag, and you intentionally or unintentionally disobeyed a traffic control device, correct?
Yes.
Thank you. Court appreciates your honesty. First, Officer Gertler, do you have any information on that plate?
Yes, it is current and up to date. For the expired plate portion of this, I would like to dismiss that citation, please.
Okay. That plate is dismissed. Mr. Weldon, whoever has that birthday, will keep having them for years to come. So you'll know what to do next October.
Yeah.
And with respect to the signal or the device, the stop sign, what would you like to say?
Here we go.
So I guess that's where a bunch of people park at to like hang out and stuff. And,
okay.
So it's my girlfriend was hungry and she had that time of the month for girls.
Okay. Excuse me, what?
She got mad at me because I said I didn't want to park because the parking there was all messed up. So
okay.
I wasn't really paying attention.
Okay.
And I guess when I pulled out, I didn't see the sign where it said right turn only, and I went straight across. And then I was arguing with her. So I know that's not an excuse, but that's the reason why.
I'm sorry.
All right.
He's like, Judge,
We could
you've had a girlfriend, right?
basically
You've
sum
been
that
through
up
this.
as much as you were distracted by a circumstance. And the most important thing we should do whenever we find ourselves in that situation is get ourselves out of traffic till that matter resolves, however that is to happen. Okay? So the court can empathize with your circumstances, but needless to say, Officer Gertler.
Yes, Your Honor. I would like to make a motion to amend that to impeding traffic, please.
Very well. That's going to save you considerable grief, Mr. Weldon. Impeding traffic is a 0-point violation, will not appear on your master driving record. That's acceptable to you?
Yep.
But when your girlfriend finds
Very
out
well.
they
Your
used her as
original
an
plea will
excuse,
absorb a plea to impeding traffic. The fine is $175 payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. The court is marking that due within 14 days. That completes your hearing. Good luck to you.
Thank you.
he tried, but he had a girlfriend, I think is the operative word, had a girlfriend. She was hungry and angry and wanted food now, and so I parked illegally, or whatever it was. I didn't even listen to what the offense was. Oh, is this the
Following
girlfriend?
case number 26, RO 01560, People versus
I haven't seen this
Olivia
one.
Lee Dish. That's you?
Yes, Deesh.
Is Dish. Thank you. Ms. Dish, you were present earlier when the court explained the informal hearing process, correct?
Correct, yes.
So you understood the court to instruct that you must select from one of three options to protect your rights. True?
Yes, Your Honor.
Ms. Deesh, the citation before the court was issued March 21 of this year at a little bit past midnight. You were operating a 2011 Ford Fusion, gray in color on Woodward Avenue, M1 at or near Normandy. At that place in time, you were cited for speeding a minimum of 1 to a maximum of 5 miles over. However,
1 to 5.
the officer's apparent radar reading clocked at a 61 and a 45. Regardless, this was written for 1 to 5, and today's your day in court. You may, if you wish, admit responsibility. You can admit and explain, or you may deny responsibility. The court will swear the parties and conduct your trial. What do you wish the court to do for you?
I would like to pick the second option. I would like to admit guilt, I guess with explanation.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed by at least 1 mile.
Yes, Your Honor.
Thank you. What would you like to tell the court, Ms. Deesh?
I don't know if this is exactly a reasoning for it, but on the night of, I was just driving into downtown Royal Oak to pick up some friends. I was offered to drive everybody home after a night at the bar. I'm new to the area. I'm not from Royal Oak. I live in Pontiac. I just moved to the area.
She was a designated driver.
I was just kind of cruising. When I got pulled over, it didn't kind of register in my mind that I had been speeding. And then he told me, and I completely understood, like, yep, I wasn't paying attention. I had a lot on my mind. I got laid off from my job that same day. So I was kind of just overthinking things, not really paying attention to my speed.
You got to give her designated driver points, though, Judge.
There is an option to do something like a class online. I would be more than happy to take that, but I just wanted to take the opportunity to come and at least try.
Okay.
So I really appreciate it.
No worries, and the court appreciates what you're telling it. The main job of any Michigan driver is to be completely aware of the circumstances and mindful. So if you ever have an occasion where you're just having a little bit too much on your mind, it's good to get out of traffic for a minute for your own safety and the safety of those around you. Officer Gertler.
Yes, Your Honor. I would actually like to make a motion to dismiss this citation in its entirety.
There you go.
Very
Designated
well.
driver
There's a motion
resonates
to
with
dismiss. The court can't imagine you have a problem with that, Ms. Deesh.
No, I don't. Thank you.
Have you found new work yet?
I have not. it's been a little bit of a struggle, but I'm working on it, and I really appreciate this has kind of been on my mind a lot last week.
Well, push this one to the side,
Yeah,
and
thank you.
as I tell my sons, keep cranking out those resumes. You take care now. Good luck to you.
Thank you so much. Do I have to? Is there a court fee that I need to pay to you?
You need to do nothing. You're
Okay.
all set. Just drive
I
safely.
appreciate it.
Good luck.
Thank you
Good
so
luck.
much. Thanks.
It's a good thing she didn't say, "Ha, sucker," as she was logging out. The officer does look like he's sort of in a Temu glamour shot booth. Or maybe, who said it, the 8mm film projection. Yes, that's probably another way.
Calling case number 26, RO 01233. This is People versus Marshall L. Bennett. Mr. Bennett, are you available?
Yes, I am.
Thank you very much. Mr. Bennett, you were present earlier when the court explained the informal hearing process, true?
Yes.
And so you understood the court to instruct that you must select one of three options to protect your own rights, true?
Yeah, you're right.
Thank you. Mr. Bennett, the citation before the court is a relatively simple one. Indicates that on March 4 this year, about 6:45, you were operating a 2026 Toyota gray in color on Crooks Road at or near Webster in the city of Royal Oak. At that place and time, you were cited for exceeding the posted speed by a minimum of 1 to maximum of 5 over. That is a posted 30-mile-an-hour zone there. Officer Gertler's detailed note on your citation indicates a radar reading of 51 and a 30, but he wrote it for 1 to 5 over 30. Regardless, today's your day in court, Mr. Bennett. You may admit responsibility, you can admit and explain, or you may deny responsibility, and the court will conduct your trial. What do you wish the court to do for you?
I can admit and explain.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed limit by at least 1 mile over, correct? Thank you. Mr. Bennett, what would you like to tell this court?
I just actually, I'm new to Michigan. So I'm just getting, I was at that moment, I was getting used to our environment in the area. I don't know exactly which way I was coming from, but I know the area I was coming from, the speed limit was a little more, it was higher. So by that time, I just hadn't noticed that the speed limit changed on me. So I'm honestly, I understand it was my fault. It was totally on me. Officer called me what it was. So no complaint. But I was just a little, the change up of the speed at that moment just caught me. So it was no big deal.
Thank you very much.
Well, it's a big deal.
The court appreciates your remarks. As a future safety tip, the less familiar we are with an area, the more carefully we should drive.
Yes, sir.
And Crooks Road is appropriately named because it's got a lot of turns on it.
Yeah, I see now.
Yeah. The first time you run that, you're like, what? Where is this taking me? So anyway, okay, I appreciate that, Mr. Bennett. Officer Gertler, anything you want to share?
Yes, Your Honor. I'd like to make a motion to amend it to an impeding traffic, please.
Very well. There's a motion to amend to impeding traffic, Mr. Bennett, that is a 0-point violation, will not appear permanently on a master driving record. That's acceptable to you? Yes?
Yes.
Yes,
All right.
Thank you, officer.
So the court's going to assess the fine of $175 that is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days. Please drive safely. Take care.
All right, thank
you.
Judge has a little song in his mind as he hums, "What am I drinking?"
Calling case number 26, RO 01320.
Dirty Mountain Dew.
This is People versus Rama Jamal Fidel. Mr. Fidel, are you available?
It's basically cream soda and Mountain Dew.
Rama?
Yes,
Jamal,
Your Honor. Can you hear me?
We got you now.
It's good cold. It's
Mr.
not
Fidel,
good
you're
warm.
available?
Yes, sir.
Thank you. And your car is stationary?
Yes, sir.
Better be.
Very well. Mr. Fidel, today's the date and time set for your informal hearing. An informal hearing is civil. It is not criminal. Nobody's going to jail today on this citation, but it is considered serious enough that Officer Gertler issued the citation on the date in question, which was March 8th. This year at about 10 p.m., you were operating a 2014 Hyundai.
I want to
silver in color on Woodward Avenue, M1 at or near Chester Street in the city of Royal Oak. At that place and time, you were cited for impeding traffic, which is a 0-point violation and doesn't record on a permanent master record. However, the officer's detailed note indicates there was a speeding situation, 66 and a 45, and in the place of a speeding ticket, he issued an impeding ticket. Regardless, today is your date and time for your hearing. Mr. Fidel, you may admit responsibility. The court will attach a fine between 0 and the maximum, and that'll close the case. You can admit responsibility with an explanation that you believe mitigates your circumstances, or you may deny responsibility. The court will swear the parties and conduct your trial. What do you wish the court to do for you?
Your Honor, I will deny responsibility.
Very well. Please raise your right hands.
We got a fighter.
Solemnly swear the testimony you shall give before this court shall be the truth.
I swear.
I do.
Thank you very much. The officer has the burden of proof, Mr. Fidel. Then it will be your turn.
Yes, Your Honor. Yes, Your Honor. On the date and time listed, I was operating in my patrol fashion in the city of Royal Oak. The radar was tested before and after shift, both with pass rating. I am radar certified. I was operating northbound Woodward at this given time. There was a moderate amount of traffic. I visually observed the Hyundai Ascent traveling southbound at a high rate of speed, passing other normal flow of traffic. I activated my front moving opposite direction radar and received the target speed of 66 and a 45, along with the audible tone to match that of that vehicle. Proceeded to make the turnaround and catch up to the vehicle and initiate the traffic stop. Given our roadside conversation and seeing this vehicle numerous amounts of times throughout Royal Oak, operating as a DoorDash driver, I believe that it was, I decided to cite him for the lesser offense of an impeding traffic violation.
Thank you. Officer Gertler, you indicated that the radar unit was tested before and after. I don't believe you suggested there was any radio frequency interference or any other vehicles in your target cone, correct?
There was no other interference or anything. There was the several other vehicles in the radar cone at the time that were traveling at normal speeds, which is why I visually targeted his vehicle, as it was clearly traveling at a higher rate of speed than the rest of the traffic.
Thank you very much. And exactly where was the vehicle located when the traffic stop was conducted and you ended up speaking to the motorist at the window of his vehicle? Was he still on the roadway?
We had pulled off the roadway at the northwest corner of 12 and Woodward by the cemetery there.
Okay. All right. Thank you very much. Unless there's any rebuttal testimony, Mr. Fidel, what would you like to share?
Your Honor, I was actually doing Uber Eats at that time. I picked up an order from Terra Kitchen. It's located on 15 in Woodward. Your Honor, I've been doing this for almost 3 years in the area, and I was not in a rush to my destination. I was focused. I was going the speed limit. There was, I believe it was a BMW, a black car behind me that was going faster than I was. Most likely the radar caught that speed. Most likely the radar didn't catch the rate speed that I was going. There was no way for me to go 21 miles per hour over the speed limit in that area. As I said, I have been there for almost 3 years. I have never got a ticket.
The car behind you could have?
And such that this kind of tickets. I would have really appreciated if I was actually speeding and the officer already took it down to an impeding traffic. But I'm really, really sure and confident that I was not speeding at all, and I was going the speed limit. And as I mentioned during the stop to the officer, that I was driving along another cop in a Ford Explorer, which indicates that I was not speeding at all. Otherwise, I would have gotten pulled over by that officer that was going on the same way, going southbound on Woodward. Your Honor, also, I got pulled over around 1.8 miles down the road, which I believe is kind of a really long distance for me to get pulled over from where the officer caught my speed.
Mm-hmm. Okay. What is the speed limit on Woodward there?
45.
Okay. And is there anything else you want the court to know, Mr. Fidel?
If possible, I would like to request any recordings that was taken, a dash cam recording, if possible, during that when the radar detected my speed. Okay. And if there is any type of certificate or history records regarding that radar, that would be good.
Okay. That may or may not be a request related to an appeal of any potential ruling. Court does not know yet. The court now turns to Officer Gertler once more for rebuttal testimony.
The only thing that I wish to add on rebuttal is pertaining to the amount of distance that it took for me to stop the defendant's vehicle, which is directly correlated to the speed at which he was measured. As regards to the dash cam, I do not have current access to that, being as though I am at home. However, it is available. He would just have to make that request through the police department in order to receive those documents through FOIA.
Thank you very much. The court has a couple of questions confined to, obviously, the direct testimony of Mr. Fidel, but in the context of rebuttal, where, if anywhere, did you attend the police academy?
I attended the police academy at Oakland Community College in Auburn.
Very well. And what, if any, other training have you received prior to becoming a sworn peace officer?
Prior to becoming a sworn peace officer, I operated as a military police officer for approximately 8 years in the United States Army.
Thank you. And with respect to that training, at any time were any of the training modules or subjects or chapters, what have you, related to both the operation of radar and visual estimations of speed?
Yes, I've received several different blocks regarding that topic.
And with respect to a traffic stop, when a police vehicle illuminates its lights and siren, in essence, that requires other vehicles to immediately begin to steer clear and around. Isn't that true?
Yes, that's correct.
Thank you very much. The court has no further questions within that context of rebuttal testimony. Mr. Fidel, the way this works is this is a civil case. It's not a criminal case. So the officer has the burden of proof. He testified first, then you testified. Because he has the burden, the court rules provide him the opportunity for rebuttal testimony, which he did take. The court had a couple more questions for clarification that were based upon your testimony, Mr. Fidel. So the court is ready to rule. And first, the court notes that this is a civil case. The burden of proof is a mere preponderance of the evidence. Secondly, the court notes that it has absolutely no idea what your driving record might look like. The court doesn't review driving records before it starts a docket. It wants to judge every case fairly on the merits regarding the day in question only. The third is that the court wants to believe, having been in and around courts in the state of Michigan for the last 40 years, that all parties are proceeding in good faith under oath based upon their best recollection and perception of the events in question. All that being said, while the officer has not made any motion to amend, which is possible in the context of motion practice, the court does believe the burden for impeding has well been met by a preponderance of the evidence. The court is finding you responsible. Mr. Fidel, the fine in this matter is $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 7 days. If you wish to appeal the court's ruling, you may do so by posting a $175 cash bond. Within 7, the matter gets placed on a formal hearing docket. The city gets represented by a city prosecutor. So either 175 as a bond or a fine within 7. Please be careful out there. Good luck to you.
Thank you.
He lost.
And
any surprises?
I think you've exhausted your folks. Is Mr. Dalton? He's not yours. Denhigh is not yours. So you're all set.
All right. Thank you. Have a good rest of your day, Magistrate.
You as well.
All right. We do have a double murder case coming up. 19-year-old Nathan Martinez, think you read pen for this, was arrested in late November 2023, charged with multiple offenses, including capital murder. There are 2, I believe, drive-bys that this should be related to. So Judge Boyd is doing her regular docket stuff until this afternoon when the case starts, and we're going to be picking it up then. It's a little court hopping until then, but it's a big case. It's a big case. What was I drinking? I was drinking... I think I told you this. By the way, Stephanie W., let me just... If you look at Stephanie W.'s picture right here, well, this picture looks familiar. Stephanie, do you want to tell the class about this picture and why there are 2 people in it and why you're both wearing identical shirts before I do? Hang on 1 second. I need to find the picture. Hang on. I have a call. Who is this? I don't think it's Stephanie W. Hello? 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 It's a prank call, but they didn't answer. Okay. All right. Says no, it's not you. Oh, just Stephanie. No, it's not me. It's.
Good morning, Officer Michael.
Good morning.
That's still a source of confusion for the court.
It's got to be you.
We'll get used to it.
Yeah.
Mr. Stacer, are you there?
Always.
It is.
All
just
right.
Stephanie.
We've got a few, but I'm thinking it might be more efficient for you to do them all in one fell swoop.
1 second.
I like that.
Can you hold,
Would
please?
you prefer that?
Hold. Okay, we're trying to sort this out. Okay. Paula Mack and just Stephanie. I don't know what this is really in relation to, because just Stephanie, it is you. Greeners designed the shirts. Those shirts, and I'm going to try to get this picture sent to the both pictures. Sent to my computer. There's one. If it'll work. Come on. Go already. Okay, it's not letting me transfer pictures. So I have to do it the other way. Bummer. Okay. We have 2 pictures. Change this to autofocus. Camera 1, cut, turn that off. We have just Stephanie and Paula Mack, who met up at the zoo wearing matching shirts. And the shirts are designed by Greeners. It says Recovery Addicts in the Wild. Nature knows what you did. It's a pretty cool. Let me get this off the screen so you can see. There we go. Pretty cool design. Thank you, Greeners, and thank you, Paul Mack and Stephanie W. for sharing that. Glad you guys got to meet up. Hope you had a wonderful time at the zoo. That's us. We had a blast. It was really cool, and thanks for sharing pictures. All three of you involved, Greeners, we're counting you as well. That's awesome. So even a blind squirrel finds a nut. Yes. All right. Now we've got a couple options. We can go to, we wait for court. We've got this one, which we've been to before. We can go back to Star Trek. We can go back to Judge Urich in Royal Oaks.
I like that.
Let's do that. All right.
He says he likes this one.
Thank you so much.
And I got a quick sentencing turn 35th to do. They said in 5 minutes they'll be ready, so just trying to juggle accordingly.
This timing is perfect. All right, we'll bring you in and get you comported when we're ready to roll on those custodies. Thank you.
Bingo.
Katia, I was there in spirit. Wonderful. Shelly, thanks for sharing the news. Hopefully your grandson gets out of the hospital today. Oh, surgery up ahead. That's scary stuff. Thank you for sharing. We can add you to the list of people we send a little prayer up for.
Good morning. If you can see and hear these proceedings, please give the court a thumbs up. Thank you very much. Welcome to the 44th District Court. I'm Magistrate William Urich. We are about to commence a traffic docket.
Yes.
If you were issued a citation by Officer Smith Meckel of the Royal Oak Police Department, you are in the right place. Please listen carefully. The court's going to explain the procedure to you as a group and undertake your matters one at a time. So to begin with, these are civil proceedings of a non-criminal nature. Nobody's going to jail today on their traffic ticket. However, it is considered serious enough that the officer issued the citation on the date in question. You will be required to make a selection from one of three options and three options only in the protection of your rights today. You may, if you wish, simply admit responsibility to the citation. The court attaches a fine between 0 and the maximum, and that will close the case. You may also, if you wish, admit responsibility, but with an explanation that you believe mitigates your circumstances in this case. Your third option is to deny responsibility. That is absolutely your right and your privilege if you do so. The court will swear the parties under oath. The officer will testify first. They have the burden of proof. Then it is your turn to testify. Tell the court what you want the court to consider. Then the court makes the finding of responsible or not responsible. But please recall that since we're in civil court, that burden of proof is a very slight one. It's a mere preponderance of the evidence, otherwise known as the featherweight test. So with that said, if you have a documentary matter involving plates or insurance and you have taken care of that circumstance, please have that document ready. That'll assist in speeding your matter along. I will excuse you back to the waiting room and bring you back one at a time.
Judge just excused himself to the waiting room. You're going to have to bring yourself back, Judge. I think you clicked the wrong button. Well,
Court calls case number 26-RO-01815. This is People versus Janan Denny?
Daney, yes.
Daney. Ms. Daney, you were present earlier when the court explained the informal hearing process, yes?
Yeah, like
just a minute ago.
Oh, yes.
Yeah, okay. So the court explained that you must select from one of three options to protect your own rights. True?
Yes.
Thank you very much, Ms. Denny. The citation before the court was written on March 30th of this year, indicates that at about 7:20 in the evening, you were operating a 2016 Jeep, gray in color, on Woodward Avenue, M1, at or near 14 Mile Road in the city of Royal Oak at that place and time. You were operating with an expired plate that had gone stale back on May 28th of 24, so your birthday in 2024. You may admit responsibility in this matter. You can admit and explain, or you can deny responsibility, and the court will swear the parties and take your testimony. What do you wish the court to do?
Yes, I take responsibility. I honestly, I moved since then, and also it was just hard to kind of keep up with all of the fees and insurance and everything that, you know, comes with it. But I did get it taken care of, just for the record.
All right, thank you, Ms. Denny. Might you have a copy of your registration with you?
Well, we're gonna just zoom out just a teensy bit so that we don't all get a copy of her registration. I can see it. I'll tell you what I can read. Looks good. It's got that's a Jeep station wagon. Jeep station wagon. Nice. Nice. Okay. Looks good, Judge, to me.
Motion to just dismiss that citation, please.
This one is dismissed. Ms. Denny, good luck to you. Take care, and happy birthday coming up.
Thank you so much.
Bye-bye.
Got some messages we need to honor here that popped up throughout the live stream here this morning. And I'm way, way, way behind. Out and about with Di, member for 32 months. OG. I'm still here staying up late. Every day is killing me. Just saying.
Calling case number 26, RO01582.
Alicia loves horses, 22 months.
Royal Oak versus
Awesome.
Ryan
OG.
Alexander Dalton. That's you?
That is me.
Mr. Dalton, you were present earlier when the court explained the nature of an informal hearing. True?
Yep, true.
And you understand that you must select from one of three options to protect your rights. Also true?
True.
Thank you, Mr. Dalton. The citation before the court indicates that on March 21 of this year at about 11:15, you were operating a 2015 Volkswagen GTI, black in color, on Woodward, headed near Samoset City, Royal Oak.
Speeding.
And at that place in time, you were cited for unnecessary noise.
You modified the muffler?
i.e. Revving of engine. So this is a non-moving violation. You may admit responsibility. You can admit and explain, or you can deny responsibility. The court will swear the parties and take your testimony. What do you wish the court to do for you today, Mr. Dalton?
I'll admit and explain.
Okay, so you're confirming to the confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and created unnecessary noise with that vehicle, correct?
Correct.
Thank you. Court accepts your plea. What would you like the court to know?
Although I do admit responsibility, I will say that I was driving. This vehicle it's a manual vehicle, so you have to downshift.
Sure.
You have to use the gas to downshift. At least the way I do it, to protect my transmission and my clutch. So to some degree, I had to give it gas. I know on the ticket it says I said passenger advised me to slow down. I don't know what it wrote on the ticket. I don't have it with me. I don't know if you saw that, but I was trying to slow down, and I was on Woodward the last weekend, and I didn't know that there was a noise ordinance.
Okay.
So, knowing that, would I have done that? Would I have slowed down differently? Definitely.
So use engine brakes?
But I was not doing it intentionally, and I thought about it a lot, and I apologize to the neighbors that I have disrupted with my car.
You did apologize to them?
Well, that certainly sounds like you've already recomported yourself in that regard. There are very few manual vehicles still out on the road, but the court
but they're so much fun to drive.
is quite familiar with that circumstance. And while there's always a little bit of a rev in between gears, there are certainly common sense limits to that. Again, the court notes this is a 0-point violation. Anything from the people before the court imposes a sanction.
I've never revved
Thank
my
you so
engine
much.
to downshift.
Mr. Dalton, this is normally a $130 matter. the court's going to assess a flat $100 fine that is payable through the pay portal on the 44th District Court website, or you can walk the cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That is due within 14 days. That completes your hearing. Please be safe out there. It is the season where folks get a little bit too exuberant with the vehicles. Okay?
Yep.
All right. Good luck to you.
Regina Adams, member for 33 months. OG, creeping closer to 36 months as always. Thank you for providing us great content, company, and laughter. Thank you. Shelly Small went car shopping for one specific car and got it.
Calling case number 26, RO01313. This is people of the City of Royal Oak versus Sean Lamaris Thomas.
Love my
Mr.
grandkids.
Thomas, are you available?
Hit the 36 months. OG.
Thank you very much, Mr. Thomas. If you could see to activating your camera, the court saw you as present earlier when the court explained the nature of an informal hearing. True?
True, yes.
So you understood the court to instruct that you must select from one of three options to protect your rights, yes?
Yes.
The citation before the court indicates that on March 8th of this year, at about 8:45 in the evening, you were operating a 2012 Ford gray in color on Woodward Avenue on 1 at near Trafford, City of Royal Oak. At that place and time, you were cited for the 0-point violation of excessive tint, obstructing windows, and there was a warning for expired plates, but that is not before the court. What is before the court is, in essence, the equipment violation, in as much as the windows were inappropriately tinted. You may admit responsibility in this matter, Mr. Thomas. You can admit and explain, or you may deny responsibility. The court will swear the parties and take your testimony. What do you wish the court to do for you?
I admit.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the City of Royal Oak with a prohibitively tinted set of windows, correct?
Yep, correct.
Yep.
All right.
No
Thank you so
explanation.
much.
It's just
Have
like,
you
yeah,
perhaps taken that vehicle back to a shop and fixed that situation?
I planned on it, but it's getting worked on right now. I had other issues, so I haven't really got a chance to get with the vehicle in about a couple months now.
Okay. Well, please understand that this thing can keep on happening until such time as you get it taken care of. And just speaking kind of like a dad for a moment, one of the difficult issues with respect to windows that are extremely dark is that other drivers cannot see if the motorist of the darkened window vehicle, so to speak, is aware of what is going on in the traffic. So for instance, you're coming home from church, you're driving down any road, and there's a vehicle at an intersection ahead of you. You can't tell if they see you and if they may or may not pull out in front of you.
I'm pretty sure
so
it wasn't just front
it causes
windows,
everybody to be apprehensive. So that's just sort of a fatherly safety tip. Anything from the people?
No, Your Honor.
Okay.
No mercy from Officer Meckel. Dana Grand Jury, not an
Mr.
OG, but love
Thomas,
this community of
this,
people. Thank you.
Normally comes with a $130 fine.
This
In
Mary
order
starts
to
around
help your
lunch.
tint removal budget, the court's going to reduce that to a straight $100. That is payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. And that is due within 14 days. That completes your hearing. Good luck to you.
Yeah, thank you. I appreciate it.
Okay. I think that completes your sweep.
Yes, I think so. Thank you, Your Honor.
Enjoy the balance of your day.
Thank you.
All right, let's see what's happening in the other court.
He was guilty.
Did you break through the window or did you fall through the window?
I fell through it. Like, I was being honest. Like, I was at the neighbor's house. I used to live there, and I was at the neighbor's house. I had one shoe on,
and
like I was playing video games with her son, like next door, and I called her and I said, "Hey, you know,
So this says you went to knock on the bedroom window and fell through it. Okay. So here's the thing. I have a couple of issues, Mr. Segrist. Number one,
You're lying
if
to
you
me.
did not do what they charged you with, then you're not guilty and you need to go to a jury. But the second, Mr. Smith, did you have an opportunity to see that there's still apparently some issues with contact?
We need to back up.
There
just
is,
a little
Judge.
bit. We need to back up. He fell through somebody's window. I'm not buying that.
Mr. Lewis, you have Eric Segrist. It's a sentencing.
This story is doesn't pass the sniff test for me. I had one shoe on. I was playing video games. I went to call her, fell through the window. What? Let's try this over from the
Eric
beginning.
Segrist.
I'll give you points for wearing the Columbia brand shirt, though. Love the fishing shirts, long sleeve, good choice. Bold move. It is summer.
Good morning. Are you Eric Segrist?
Yes, ma'am.
Mr. Segrist was previously in court, entered a plea of guilty to burglary of a habitation, 2nd degree, and that was for a 10-year term in prison to be probated. I've received that pre-sentence report. Have you all had an opportunity to review that report?
Yeah, Judge. Yes, Judge.
Additions, corrections, explanations?
Well, Judge, I did speak with Mr. Segrist about some of his statements he made during the PSI report. And I think it was a situation where I think he stated that he didn't feel guilty, but I don't think that was the issue. I think it was more the remorse. He does understand that he was guilty.
Did you break through the window or did you fall through the window?
I fell through it. Like, I'm being honest. Like, I was at the neighbor's house. I used to live there, and I was at the neighbor's house. I had one shoe on, and like I was playing video games with her son, like next door, and I called her and I said, "Hey, you know."
So this says you went to knock on the bedroom window and fell through it. Okay. So here's the thing. I have a couple of issues, Mr. Segrist. Number one, if you did not do what they charged you with, then you're not guilty and you need to go to a jury. But the second, Mr. Smith, did you have an opportunity to see that there's still apparently some issues with contact?
There is, Judge. She did not contact me until when she thought that it was probation that contacted her. So,
have you reached out to her?
I have not.
Okay.
I have met with her. I brought her in. That was one of the reasons we offered this deal. It wasn't what I wanted to offer based on the facts of the case, but she was reluctant to come in to testify in trial. Sounds like that has changed, but I think she vacillates.
So let's do this. I'm not going to reject today. I'm going to reset the case for 2 weeks. Mr. Smith, I'm going to ask if you'll get in touch with her and see what her position is with regard to these allegations. If there's actually some video footage and things like that, I think that would be important for the deal and potentially a bond. Mr. Segrist, and I'm sure Mr. Lewis went over this with you, there's some allegations that you are still contacting or harassing, being around, potentially in the past. I mean, if you're the one that is on video doing the things that she's saying is happening, you're going to be in jail in about 1 week. You understand?
Yes, ma'am.
So I don't know what's going on. I am going to order that today, by the end of the day, you are required to have a GPS monitoring device put on.
Yes, ma'am.
You can talk to your attorney and you can talk to your bondsman. They will tell you where you can get that done. It has to be on by 5 o'clock today.
Yes.
I need proof of it. So you need to get proof to your attorney so he can get it to me.
Yes.
If you don't have a GPS monitoring device on by 5 o'clock today, there will be a warrant issued for you at 5:05.
Yes.
And
5:05,
you are to
precise.
have absolutely no contact, no communication.
Selena, thank you very much.
No, you cannot go to her work, her other family, her anywhere that she is. You cannot be there. Do you understand? If you're somewhere in a store or something and she shows up, you're the one that has to leave. Doesn't matter if you're there first. Does that make sense also?
Yes, ma'am. Absolutely.
This is you and your ability to stay out of potentially a prison for a very long time to follow these rules. If you choose not to, then you will end up in prison. Do you understand? I don't have to accept this plea agreement. You can go to a jury and let them hear all of this and see if they want to buy the story of you fell through a window. All right?
Yes, ma'am.
All right. We'll see y'all in 2 weeks. You're free to go.
How can he be in jail in 1 week if you're not going to see him again?
Yeah, and also that's remain in Jefferson County as well.
Okay.
But I took that.
Fell through the window of my eye. Sorry. Yeah, that didn't sound very believable to me.
Mr. Rojas, you have to Sean Bass.
Yeah. Sounds like he was on the run. Either to or from something.
Good morning. Are you to Sean Bass? And this is 25 DCCR 0832 and 0833. Mr. Bass is charged with aggravated sexual assault of a child in each of those cases. And Mr. Rojas, what is the announcement?
Judge.
Let's see. Let's go up to 13th, shall we? 13th is right here.
Of submitting to that. And so, at least as far as the state's position today, I do think that is what we have to do. I don't believe the report says anything about never going to be able to obtain competency. That may be
Ayden Avery has a guardian
true.
angel.
I just don't know if we know that today, and I don't believe that's what the report's saying.
Well, and Mr. Patterson commented that some of that was from his history that he'd learned. The problem is, can we even get a bed for him within 90 days?
Judge, in that other case, again, my client was out on bond just because of the circumstances. I think we have those here. When the bed did come open, then there was a family transport that took him there. We just kept track. But no, it took, I think in that other case, 7 to 8 months before we got notified of a bed date.
And court security 1 or 2, either one. I know that isn't one of the things you usually take, but do you happen to know what the waiting list is? Have you talked to anyone out there at the jail? Because they know when the bed spaces are. Even though this gentleman isn't in jail, they know how long they're keeping these folks, and they send us a notice every now and then that it's so many more days he's waited and so many more before they get a space.
Your Honor, I am unaware of what the bed space is like out there. I could have somebody call the jail and try to find out.
Yeah, I was just hoping someone knew off the top of their head. Thank you, though. Well, the only thing I can do then, since he's not in jail, which is a good thing, that we're not keeping him locked up for mental issues, like some have to be. But all I can see myself doing and trying to comply with the statute as the best I can, but not completely, or as I'd like to, is order that he be put on the list for a competency evaluation. And as Mr. Patterson said, as we've done in the past, the family agree to take him when the bed becomes available. I'm a little nervous about this because the nature of the charge being assault, criminal damage to property. Those are kind of dangerous, potentially dangerous charges.
Yep.
We have also Mr. Patterson, and I'm picking on Mr. Patterson, Mr. Buck, because I know you haven't been in the jurisdiction quite as long. Mr. Patterson, we've done something in the past where we order outpatient. Remind me how we did that.
Judge, for a period of time, South Central Mental Health did have a person who was trying to do restoration locally with folks at the jail and at South Central Mental Health. That person is no longer there. I was going to reach out to see if the new person they have doing the evaluations can also do outpatient restorative treatment. And I'll let the court know. I don't know at this point.
Well, for now, the best I can do, I find he is incompetent. I order him to get further evaluation and treatment at the state hospital as soon as a bed becomes available. And when that does so, then we will set this for review, for further review. As one of you said, 90 days out after he starts his treatment and evaluation. But in the meantime, I'm going to have to set another court date so that we don't just lose track of this case. So, Jennifer, you want to go for that July 20th?
Yes, Your Honor.
And
right.
what shall we call this, attorneys? Competency review?
Please, Judge.
Okay, competency status review.
There we go. Judge, we're going to bail.
To see if we've made any progress.
We're going to bail. Sorry.
Good morning. Are you Luciano Richard?
Yes.
And will your client waive the formal reading of the indictment?
Sure, Your Honor.
Everybody waves unless they have a.
All right, ma'am. In clause number 25, DCCR 1611, you're charged with the state jail felony offense of theft of property with previous convictions, and that's from August 14th of 2025. The indictment alleges that you were previously convicted of theft October 14th of 2022, and then after that was final, June 27th of 2024. And how do you plead to that charge? And are those two prior convictions true? And did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. And part of that would also include a no contact order with Ibriana Bell. Do you understand?
Yes, ma'am.
Is there any restitution?
None, Your Honor. I believe they have stopped. So there's no restitution.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Richard is not competent?
No, Your Honor.
And what's the state's position with regard to PSI?
The court may want a PSI in this case. There's criminal history, albeit misdemeanor criminal history, other than the theft.
All right, so.
The thefts, I should say.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea.
Judge, also, there may be some restitution if we can have probation look
Sure.
at that. Yeah, the theft from HEB, Judge, I thought that they'd stop them and recover items with Mr. Rojas.
We'll get it looked at.
There may be some things that they didn't get back.
So I find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Also, if there's any restitution, that can be determined between now and then as well. You need to stop on your way out of the courtroom today and talk to probation, and she's sitting at that desk right over there.
Yes.
All right, we'll see you back at sentencing.
We're going to take a look at Judge
And
Boyd's
then
court in just a
Whitley
second.
Shepard, Mr. Rojas.
See how she's doing today before her trial starts.
Good morning. Are you Whitley Shepard? And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Ms. Shepard, in cause number 25, DCCR 1146, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon.
Whoa.
And that's from June 1st of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand that? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. there would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Yes, ma'am. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Ms. Shepherd is not competent?
Oh, yeah.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and we'll come back later for sentencing. You need to stop on your way out of the courtroom today and talk to probation, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Thank you. Thank you, Mr. Rojas.
Thank you, Judge.
Thank you, Mr. Pickles.
Stefan Diggs is a really short trial, Nanny. Well-known defendant, but
Mr. Smith,
could be like one
you've
day
got
or 2
James
days.
McEwen.
It's gonna be really quick.
Good morning.
We're gonna jump to Judge Boyd real quick, see how she's doing.
Home issues, I'm not putting it on nobody. This is mine. I think that, but I had issues at home and I wasn't ready to figure this out with the family help that I have now. Everything at home is taken care of, and I couldn't worry about myself right now. You know what I'm saying? And
you start using it?
I was using, and
And what is up with this not allowing them to search your person or your residence? Because obviously, if you're pleading true to not allowing them to search your person or your residence, that means, and I'm making an assumption here, and if my assumption is incorrect, let me know. That seems to suggest that they came to your house wanting to search and you told them no.
they searched and they found smoking devices, and I was using, so I would have had a little bit more of substances. Your assumptions are correct.
All right, just one moment. Is anybody's Odyssey not working properly?
Is a Honda Odyssey?
Thank you. I just wanted to know if it was me, because technology and myself are not very well. All right, so continue.
No, I mean, it was just, I stopped the search after they found the smoking device and pipes there, and had they continued searching, they would have found a little bit more drugs, you know what I'm saying, too, that I was using, and I stopped the search, I guess, at that point.
All right, does anyone have the trial court summary?
I have the court summary, Judge.
Yeah. Any objections to the court reviewing that?
No, Your Honor.
All right, thank you. Let me see. They're telling me to try Odyssey now.
Working out, Judge.
All right, I've had 2 people say it's working now. We're gonna see.
Have you tried turning it off and on again, Judge? It usually works.
Sorry.
Does it not work?
Slowly, let me see if it will let me in. And see, I kept telling everyone, what happens if Odyssey fails? And they're like, oh, it'll never fail. Okay.
Well, today is the day.
There we go.
Somebody just sent me a video of roaches fighting. I don't know who won.
Hang on, is this a real thing?
All right.
A Baltimore bakery truck was hit by United Airlines plane coming in for a landing at Newark Liberty International Airport.
Did you ever enter lifetime?
Before I got sentenced, yes, ma'am. You requested the day I got sentenced that I go back into lifetime. Probation said that there was no more funds for that. And that's why I was trying to get into, I guess, any kind of program at the time.
All right, I'm going to give you a choice. These are your only two choices. Don't ask for a third. One, I'll revoke you and I'll sentence you to 4 years in the prison. Your other option is I will continue you, but you're going to safety. Those are your only two options. Which do you prefer?
Safety is the 9-month treatment, and you might have to wait a few months before you get the bed.
Can I get the 4?
All right, see? Sometimes people won't help.
The
Sometimes
deal
people
maker, Judge.
No, I mean, I'm just, All right, the court will grant the motion. I'm sorry, are you waiving your right to appeal? All right, the court will grant the motion, revoke, and I'm sorry, state you may be excused.
Thank you, Judge.
Court will sentence you to 4 years in the prison. Give you credit for any time served.
4 years. Whoa. Order safe P.
The court will request the therapeutic community. It doesn't increase the time that you're in custody, but it could potentially help you with any substance abuse issues you may have. There's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you, ma'am.
You're
Thank you,
welcome.
Honor.
All right, anyone else ready?
Yes, Judge, page 2, fourth one down. For Joel Leon.
Julie Hahn,
Yes, Your Honor, that's gonna be a reset.
where's your client?
Is it Leon, you want him up here?
Yes.
Leon. I confer with the state, confer with my client. We need some extra time for litigation to do the plea.
All right. So do you have all discovery?
Yes, Your Honor.
All right, stay. So
that a
today
polo
was
zip?
supposed to be the plea deadline date.
Correct. And he's done some classes up front, but he needs to do one more in order to get the mitigation plea that we want. So we're just asking for a little extra time.
And how much time are you requesting?
30 days at the max.
All right, Norma,
Yes.
recall this in 30 days, and that will be your final plea deadline date.
Yes, ma'am.
June 4th.
June 4th, that's perfect.
All right,
Thanks.
thank you. See you then.
Thank you. Okay.
You're welcome. Who's next?
Page 8, first one, Grant Barron. You need to sign? Yes.
Grant Barron,
If she like be in the middle of it.
for deputy safe attorneys on this side, client in the middle.
Fine in the middle. All right.
You know, this guy dressed
should know these
appropriately.
things, but
He's
I
wearing
asked him.
flannel.
All right, where are we on discovery?
New items just came to the state's attention from defense that he's wanting, so I need to reach out to the victim to see if these still exist, and if they do, I will provide them to defense. They are new medical records that she may have gotten some imaging work done prior to the medical records that I have already disclosed to defense. Additionally, there may be home surveillance footage that if it still
Is the
exists,
defendant
I
and the
need to
lawyer related?
get that and produce it to defense.
All right, Ms. Ferguson, 45D reset, final discovery.
They look like they're related.
All right, June 18th. Once you sign the reset form, you'll be excused. Thank you.
Yeah, check my calendar, Judge, just in case that's
Oh, you can have a seat.
yeah. I think that's fine.
All right. Who's next?
Page 3, second and third one down, Laura Alanis.
Sorry, I've been ignoring chat. Let's see.
Lauren Alanis. Hello. Good morning. All right, State, were you able to tender an offer?
Yes, Judge. You're gonna have to fight for.
We've been conferring. We're going to submit an application for PTV today, Judge. We haven't done that yet.
All right, I need a PTD date, please.
Yes, and I can do the.
All right, and counsel, that needs to be filed today.
Yes, ma'am.
All right, thank you.
Thank you, Judge.
Guess we have to say rest in peace, Spirit Airlines as well. Shut their doors over the last few days. Rather abruptly. But if you haven't flown Spirit Airlines before, you're in luck. You never get a chance to.
All right, who's next?
On page 4, first one down, Ubaldo Navarro.
I'm present.
Page 4.
A lot of people in the courtroom, Judge, to get through before this next court case.
Mr. Navarro. Sorry, wrong person. All right, Mr. Navarro, if you could unmute, please. All right, where are we on
Hello.
discovery?
Yes, John, I did get out of discovery and I do have a plea offer. I just need about 3 weeks reset on this matter.
All right, Ms. Ferguson, I need a 3-week reset for a plea deadline date.
May 26th.
All right, May 26th.
Thank you, Honor.
All right, and Mr. Navarro, you'll need to be in court for that unless you're out of county.
Okay, ma'am. Thank you.
All right, thank you.
I'll make sure I'm out of county.
All right, who's next?
I have page 2, fifth one down, Lawrence Tucker.
Lawrence Tucker?
Yes, Your Honor.
Yes. All right, what is the update on VTC?
Well, that's the thing, Judge. Mr. Tucker has been in contact with VTC. He spoke with Ms. Dina Ruiz. She requested his DD 214, which he provided approximately 2 weeks ago. Hasn't heard anything since. So that's where we are. We're kind of in limbo, Judge.
Oh, just have a moment. Let me see if I can get someone to come up here from VTC.
Very well, Judge.
All right, thank you.
They're still in trial. But I'll have to go to 227 shortly, though, Judge. But I'll wait.
All right, thank
Yes,
you.
you will. Pam Jam's member for 38 months. OG. Thank you, Ari, for birthday song. You made my day. Pam Jam's happy birthday. Thank you for being here. Congratulations. Y'all see what happened on the Kentucky Derby over the weekend? Something that's never happened before.
Hello.
Last
Hey,
place.
how's it going?
25 lengths
I'm going okay.
behind.
There's a guy up here, Lawrence Tucker.
Who runs the full distance and wins it.
You all had asked for his DD 214 or whatever document. And so he's provided that. And I'm trying to get an update. Okay. All right.
First
thank
woman
you.
trainer to win the
Goodbye.
Kentucky Derby as well. And watching the video of
All
her
right.
was incredible.
Lawrence
By a
Tucker,
neck.
VTC is coming up to
By a
get an
nose.
update. Yes, sure.
Stacy Ray, congratulations on your jury summons. Remember, the ones who talk the most get dismissed the first, but always tell the truth and answer all questions honestly. Judge is taking a little break. Prosecution's just chilling. There's a lot of people in court today. There's no way we're getting through all of those before the case starts. It was crazy. Of course, I randomly chose Great White, and he was the one that bucked and threw his jockey off right before Driftwood. I'm so sorry. That's probably the worst possible outcome, when the jockey is not on the horse at the start of the race. Texan, if you'd like, we can facilitate that. If both of you text the burner phone, and we can make that connection. Also, you can try Discord and message each other directly if Discord's an option. That keeps me out of the middle, but either way, we're happy to do that. Let's see if we've got anybody else who's doing anything interesting. Let's go back up to the one we were watching a second ago.
Good morning. Are you James McEwen?
Hi.
And this is cause number 25 DCCR 1186. Mr. McEwen is charged with theft of property. And what is the announcement?
Yeah, this is a first setting, and this is a theft by, basically a theft by check case to fill out for some
Transmission work.
Transmission work. And I'm having my clients put together a bunch of bank records to show there was
Okay, I'll just need some more time. So Mr. McEwen, I'll reset any issues with resetting. I'll do a normal reset to give you time. Mr. McEwen, anything that you think is important for Mr. Smith to have, make sure you get that to him quickly so he can get it to Mr. Coleman. They can discuss your case and you can see what your options are. All right, thank you. Feel free to go. See, is Mr. Ward here? Mr. Ward, are you ready on your sentencing? On Bart Thibodeau? Good morning. How are you?
Traffic was a little bad coming in.
That's all right. Thank you. Good morning, sir. You're Bart Thibodeau. And Mr. Thibodeau was previously in court and cause number 25 DCCR 0339. Entered a plea of guilty to the state jail felony offense of solicitation and prostitution. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
I had.
I have, Judge, and if I may,
Yes.
I have shared my feelings with Mr. Ward based on the length of time I've been before Your Honor, that this PSI obviously is less than to be desired. Obviously, Mr. Ward and I neither one knew about the lengthy Calhoun Parish issues, which can be supported by the fact that there's no disposition on them. So I'll refer to what you think is best.
It's very difficult over there.
Yes, it is.
Unfortunately. But obviously, Mr. Thibodeau, you've been in and out of trouble in court
She didn't buy
since
one
1980, since 1987 over in Louisiana. And
repeat offender.
now we're here and starting in Jefferson County. Where do you live?
Sulphur.
Okay. Are you on any kind of probation currently or parole or anything in Louisiana?
Judge, obviously our thought in offering the plea on the solicitation case was so that type of behavior would be flagged rather than necessarily the drug, that somebody would see it over
Yes.
there.
No, I'm fine. I don't disagree with that. I was just I guess the only, not the only, an issue that I have is that we don't know if there's an actual felony conviction. We just know that there's been some felonies. Those are typically mostly back in the 90s, other than the one, the obstruction of justice over in Calcasieu Parish. It looks like in 2022, there was a 2-year probation. Did you successfully complete that? All right. Anything else?
No.
All right, so I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow this agreement. I'm going to defer all proceedings and place you on probation for 4 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have this conviction on your record. And if you successfully complete the probation, at the end, the case will be dismissed and you will never have this felony conviction. The other side of that, though, is if you violate any condition of probation, which based on your criminal history, I have some concerns about you being successful. I hope you are, and I hope you change whatever it is that's going on in your life and it's been going on in your life. But if you violate, you're right back in here. You'll be convicted. You'll have a felony conviction. You can go to the state jail prison between 6 months and up to 2 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. And I will sign that dismissal as part of this agreement in clause number 25, DCCR 0755. All right. Thank you, ma'am. Thank you, sir.
Thank you.
We actually liked the Honda Pilot. That's one we almost bought. I gave Mrs. R.A. the go-ahead on the Honda Pilot and the Toyota Highlander.
Mr. Kimler.
No on the Lexuses. We also drove a Nissan Armada over the weekend, which is funny because we just sold our Nissan Armada to get better gas mileage. 11 miles to the gallon is not good.
Bruce, you don't have anything else here, do you?
I have a bar of water.
Kind of a water for me.
Bar.
No, you don't have anything else.
That's it.
And Mr. Lewis, you don't have anything else, do you?
Oh.
Okay. So we're waiting.
We're just chilling. Judge Boyd is talking with somebody at the bench.
What page is Mr. Rios on?
It'll be on page 10 or 11, I think.
All right, thank you.
11.
Thank you.
And I made my arguments last time. Do you need me to make the arguments again?
Oh, no.
Okay.
Could I have a motion?
I have a copy if you need it, Judge.
Yes, please.
You're welcome.
All right. Mr. DeLeon?
Yes, Judge.
Are you going to have any objections to the state's motion for continuance?
No objections, Judge.
All right. So when is your witness available?
She will be available the week after next week when it's currently set. She's out that whole week on a pre-approved vacation that she had gotten last month. She is necessary material. The testimony that we would be able to get from her cannot come from anyone else, and she is a necessary causal chain.
No, I'm just wondering when is she available?
Sorry, Judge. I just get into the habit
okay.
of making my arguments. Yeah, she'll be available the week after next, so at least on a continuance, but maybe at least until the next family violence.
So you're saying she's not available this week, correct?
No, next week. The trial setting's next week on the 12th.
On the 12th. So she's not available the 12th. So is she available the week after that?
Yeah.
All right. Ms.
And-
Ferguson,
Well, you see that.
put this on May 26th. All righty.
Thank you, Judge.
Thank you. Thank you, Mr. DeLeon.
Thank you, Judge.
You're welcome.
Yay. It's good. Judge, on May 26th, can I tell Atascosa County, hey, I've got a trial sitting in a
Yes.
much more important court than
Oh.
Atascosa County?
Sure, you can throw that in there.
I'll tell them that.
All right, who else?
Yeah, we're trying to get some better gas mileage.
All
than
right,
the V8.
Alejandra Amazon. Hello. Good morning. How are you doing?
Better.
Been better, she
I'm
said.
sorry, Odyssey is running so slow. I'm waiting for it to upload your case. All right, so we're here today for sentencing.
Correct, Judge.
All right, the court is calling 2022 CR 7545 State versus Alejandra Almazan. Can I have parties announced?
Brandon Prada for the state.
Ted Wood representing Ms. Almazan.
All right, and are you Miss Almazan?
Yes, ma'am.
All right, you had entered a plea of true to violation of condition number 1. And number 15 was waived without objection. And we're here today for sentencing. Okay. All right, anything you want to say on behalf of your client?
Judge, Ms. Almazan's grandfather's here. I'd like to bring him up to offer testimony. May I bring
Yes.
him up?
All right, they're going to have you step back over here, okay?
Yes, Amazon,
Yes, ma'am.
with your back to the counter.
Hello. Hello. Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Richard Gooten.
All right, you may proceed.
Thank you, Judge. Richard, how exactly are you related to Alex?
I'm her grandfather.
And how long have you known her?
Her
Her entire
whole
life.
I
Okay.
was there the day she was born. So
Okay. What is the nature of y'all's contact now at this time? Does she live with y'all?
Yes.
Okay. And does she have any children?
Yes.
How many? And where do those children live?
With us right now.
Okay. Are you and your wife taking care of the children?
Yes.
Okay. Has this situation with Alex put a strain on y'all's resources and your time resources regarding taking care of these kiddos?
Yes.
Okay. What else is going on right now in your family life that has brought you here today?
Well, my wife is going to need surgery again. Repair something that she had done in 2020 and then redone in 2021. So it's, her health is not the best right now.
Is it fair to say that she's over 39?
Yes.
Okay. You have a statement that you would like to get you prepared that you'd like to read to Judge Boyd.
Yes.
Why don't you go ahead and read?
All right, well, before you read that,
Yes, ma'am.
let me just tell you, because I always like for people to be on track. These are my issues, right? She's on probation for DWI third. She's pled true to another DWI.
Yes.
Now, a lot of what I do, one, depends on if I continue her, obviously she needs inpatient treatment because outpatient treatment isn't doing it. Then the other thing is what is happening with that new number 1. Does anybody know?
Well, she pled true to it.
Yes, I mean, she pled true to it, but what is the state's plans for that new number one? Is the plan to, we are going to continue with that? Is the plan, we're going to dismiss that and see what happens in this case? I mean, you all probably need to discuss that because otherwise she's going to be in limbo. Because even if I were to continue her and place her, continue on probation and say she's going to inpatient treatment, she can't leave to go anywhere. No place will accept her if she has this case pending. So what I would suggest humbly is that you all talk about that new number one to see specifically what's going to happen with that. And then, because that needs to be taken care of. Because even if I were to refer her to felony drug court, they won't accept her if she has this pending case.
I humbly take your suggestion.
All right. Okay. Thank
Lots
you.
of humility in
Thank
court
you.
today. I like the alls. I just like to call them out
All
as
right.
well.
On Tucker,
It's us.
A Man in His Dreams. I think I'm the only person who remembers that movie. That was a great movie.
Never seen it.
Tucker, A Man in His Dreams.
Oh, yes.
All right. Let me see what page he is on. Got it. All right. So what is the update on Mr. Tucker?
Your Honor, when I spoke with Mr. Tucker this morning and my staff, the only thing that we were waiting on, which is relatively easy, is just a letter of interest, and then we're going to schedule him for an assessment. If we get all those things done, like we talked about this morning right now, we can have them done by the end of the month.
Okay. Then what we'll do is we'll recall you for the end of the month.
Sound good?
All right. So everything should be in with them. Okay.
I'm getting done as soon as possible.
All right. When you say the end of the month, what do you mean though? I probably shouldn't have said end of the month.
I was going to ask that, Judge. What do you mean by the end of the month?
The 28th is the last Thursday, Your Honor. That's the day that we do blue folders. So as long as he has everything in within the next 2.5-ish weeks, we'll count it 3 weeks. 29th, I should have an answer.
All right. So what we'll do then is we'll set it for the week of June 8th. And you need to have everything.
It'll be done before that.
All right. Thank you. Ms. Ferguson, I need a recall for the week of June 8th. Oh, June 8th. All right. June 8th. All right. Thank you. Thank you so much for coming down. Do y'all have an update for me?
Yes, Judge. We haven't.
Oh, he's discussing. Okay.
We're just going to be running concurrently. Let's whatever you decide.
Okay. Who's next?
Williams, page one down.
Melania Williams. Hello. Hi. Morning. So today is plea deadline?
Yes, Your Honor. Today's our plea deadline date. We would have to request some additional time, Your Honor. We recently got a new offer.
Okay.
So I need some additional time for Ms. Williams to consider the offer and work on some mitigation and hopefully get this worked out in the next 30 days.
All right. How old are you? 17. All right, Norma, set this for mid-June. This is the final plea deadline date.
Yes, Your Honor. Understood. Thank you.
I can do
That'll work good.
All right, thank you.
Thank you, Judge.
You're welcome. Who's next?
It's Ruby de la Cruz, it's 2, 1 down.
Dela Cruz? Okay, I still don't have the email.
Okay, I'll send it over.
All right, thank you.
Judge, on Ms. De La Cruz, we're set for discovery. I just conferred with the state and it looks like we're still missing a couple of items. I gave them a USB and then she has 2 cases pending.
Mm-hmm.
And on the other case, it does also look like I'm missing a surveillance.
Okay. All right. Norma, give me a reset date. This is your final discovery date, 45 days.
Judge is in a good mood today.
Thank you.
You're welcome. All right, once you sign the reset form, you'll be excused. Okay.
Oh, I didn't know what you were handing me. Thank you.
You're welcome.
All right. May the 4th be with you all.
My gosh, it's
Judge
going
Boyd's
slow
trial
again.
starts at noon. The only thing she's frustrated with today is her computer system, Odyssey, which is terribly slow. Forever and a Day, birthday tomorrow. Get on the list today so we can sing to you tomorrow.
Thank you.
I do like Texans.
All right, who's next?
I got a lot of family in Texas on both sides.
Yes, please, yeah.
All right. Just 1 second. Let me see if Odyssey is back. Thank you. All right, Gabriel Diaz. Who's the attorney for Gabriel Diaz? So is y'all Odyssey still down?
It's still, yeah, the new structure.
All right, where's Mr. Diaz? Are y'all ready? Nobody's ready on Gabriel Diaz? Okay, they're not ready. Who's next?
Yeah, Gabriel Diaz. Judge Sullivan, I thought it was only once. Yes. Yeah, I'm sorry, we're ready, Judge.
All right. All right, what's happening on this case?
Your Honor, Mr. Diaz has been evaluated twice by 2 different psychologists, one in Bexar County for Bexar County and one in Kerrville for Medina County. Both of them have determined that he's incompetent to stand trial. And we are waiting for his competency to be regained so he can stand trial here and also stand trial in Medina County.
All right, so this needs to be referred to the magistrate's court. Has it been referred to the magistrate's court?
Yes, ma'am. We just came from the magistrate's court. She's the one who.
Why'd you send it back?
Okay, because I'm like, he shouldn't be up here then.
Well, I agree. I don't know why they.
Yeah, I have
put
no
it
idea.
on the docket, but.
All right.
we are.
So when are you set next setting in magistrate's court?
We are not, Judge.
Okay.
To my knowledge, the only setting I've had since magistrate court is with you.
Okay.
Judge, if I may,
Yeah.
I believe that when he's found incompetent, I came from the magistrate's court. When he's found incompetent, he needs to be restored to competency.
No, I understand that. My thing is, usually there's a date because when somebody's found incompetent, you can't just put somebody in limbo. They have to have hearings. And I believe it's 120 days in some instances. In some days, it's 90. So
go down and
there
check.
should be a setting. No, I mean, that's fine. What I'm going to do, Norma, recall this in 120 days.
Thank you, Judge.
It's the same as
September 1st.
before.
All right. And if
I've
for
got
some
the,
reason competency is not restored by that
hang
time,
on, let me-
just let us.
Surfing Girl. It's the same as before. There's no public seating. It's all for the families. 5 seats for media. We'll be given the link for our live feed for that. Still, same law and crime is going to be the pool photographer on that one, but I don't think there's a new decorum order just for that.
What page is he on?
Take 5 down.
All right. Are you okay? All right. Court is calling 2026 CR 0035571 State versus Cruz Tovar. Can I have parties announced?
Megan Galloway for the state.
Roberto Vargas for the defendant, ready to proceed, Your Honor.
And are you Mr. Tovar? Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tovar, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Tovar, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Tovar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 months in the Bexar County Jail under 1244 and an $800 fine. Did you understand that to be your plea? Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State offer states 1 in attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Read away, Judge. Yeah, care sentencing, I believe, is on the 13th. That's Corey Richens.
After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We respectfully ask that the court will accept the agreement that we have with the state.
What's the deal, Judge? Do you like it?
All right, this home where you were, is that your mother's home? Okay. All right, this is what the court is going to do. Court is going to find you guilty, sentence you to 8 months in the Bexar County Jail under 1244. There's an $800 fine, time and money to run concurrent. There's to be no contact with Maria Cristina Ramirez without her consent. There's to be no residing residence. And the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. You're going to have to make better decisions, understand? And when you are released from custody, make sure you get that checked out, because sometimes there's damages behind that, all right?
Say something?
Sure.
What's that? I'm actually in Reds because I was denied the proper treatment. I went to the hospital.
Selena, that's awesome.
We did MRIs, CAT scans. Whatever they found in those results of those X-rays and scans, wanted to give me liquid morphine and Teradol. So, as you said, they didn't tell me what was wrong, but I know that something had to be wrong for them to give me what they gave me.
Okay.
But that being said, the hospital told me to let this unit know when I started feeling the same symptoms that got me to the hospital in the first place.
His lawyer steps away from him.
Yesterday, I tried to do that, and I'm in Reds. And I just wanted to let that be known that I'm not getting the proper care that I need. And that's only because they don't want to. And it's not because I'm being disrespectful. You can look up I've never been written up for any disciplinary hearing, nothing like that. I'm respectful to all these guards. And I'm in Reds because I needed help.
Okay. So this is what I'm going to tell you. The time that you've been sentenced, if you're in general population, usually the sheriff's offices will give you 2 for 1. So every day you serve, you'll get credit for 2. Normally when you're in red, it's day for day time. But what I can tell you, I'm not over how much time they give you outside of the day for day time, okay? But when you're released, you'll need to check that out. And of course, you can file whatever thing you want to file. If you want a civil attorney, you can take care of that on that end, okay? All right, good luck to you. Thank you.
May I be excused, Your Honor?
Yes.
Thank you.
You have a good day.
Thank you, you too. All right, who else?
Guys, move with purpose. Move with purpose. We've got a jury trial
this
afternoon.
I always figure there's more to the story.
There's always more to the story.
But I do research. Okay, so Odyssey is just playing games today. Righty, who's next?
Trisha, add one down.
Patricia Adams.
While we wait, we're going to go watch.
Supposed to be a
We're going to watch a different jury
I am
selection.
asking for.
Would the officer be able to show driving? No. No. Anybody could have been driving. Maybe man was driving, maybe he wasn't. Maybe somebody else was driving, maybe he happened upon the car. And in this particular case, even though we know man was completely drunk and he was completely impaired, and he probably was driving, there's nobody else around. Do we reach here? Do we reach guilty?
Oh no, bail, bail, bail. I thought this was a driving drunk.
That is going to be a very difficult decision for some.
Nathan Martinez, page 1.
We're bailing on that one. Thank you, Josh, for
Nathan Martinez. Hello.
Morning, Judge.
Good morning. Odyssey is not working, so there you go.
It's just down.
Yes.
Not slow.
And you
it's
know,
down.
we had a meeting, and I asked everybody, if Odyssey goes down, what will we do? You know what everybody told me? Oh, no, that we got backups that'll never happen. And I'm like, no.
Backups to what they don't.
Yeah. All righty. Yes.
Okay, Judge, we're set today, as you know. However, we received from the state, thank you, Thursday
new DNA a new DNA report.
Okay.
So this, she was just handing me her notes to make
Oh,
sure I didn't,
okay.
make sure
I thought it was the report.
make sure I didn't forget anything.
Yes.
And then Friday, witness statements from witnesses that met with the DA, I guess Thursday or Friday, that had never been interviewed by police before. So considering the severity of this case, and then also,
And we don't have the forensic packet.
the DNA, in addition to the new report, the report itself is dated February, but we got it Thursday. Then also we still don't have the DNA forensic packet. And then the body worn cameras. I'll let Suzanne address the body worn cameras because
The marshals actually arrested Mr. Martinez. We do not have his report and we do not have his body worn camera. Megan is able to get some of that to me today. Now she says that it's similar to what the SAPD body worn camera said, but we don't know that. We've not seen it. We've not read the report. And so, you know,
this is what I want you all to do. I want you all to go in a room or wherever y'all need to go. And whatever is missing, find out when it will be delivered.
Judge, I guess so, because we've already conferred about it. So just so the court is clear on it. So the DNA, there were 3 swabs that were taken from a crime scene. Okay, so there's 3 different reports. 2 of them were turned over to defense in advance of the last setting that we had in January.
Okay.
During a meeting in preparation for trial this week, on Thursday, when I was meeting with the DNA analyst, he informed me of the existence of this 3rd report. So I received that from him on Thursday and then immediately forwarded it to defense.
Okay, let's do this. Let's go on the record. So it'll be on the record. All right, the court is calling.
It should be under 2024 CR 2564, Judge.
Okay. 2024 CR 2564, State versus Nathan Martinez. Can I have parties announced?
Megan Galloway for the state.
This is our
Suzanne
case.
Kramer for Mr. Martinez.
Charles Buck for Mr. Martinez.
And you, Mr. Martinez.
Yes,
All right. So off the record, the state was just explaining the DNA, but could you explain it since we're on the record?
Yes, Your Honor. So in this case, there were 3 DNA swabs that were taken under SAPD case number 2318-3729. Those swabs were sent over to the Bexar County Crime Lab. There are 3 different forensic DNA reports associated with those swabs. 2 of the reports were turned over to defense in advance of the last setting that we had in January of 2026. During a trial preparation meeting with the expert witness on Thursday of last week, he informed me that there was an additional report regarding DNA, and he provided that to me on Thursday, and I immediately sent it over to defense counsel for their review.
All right. So with the DNA report on Thursday, you were only made aware of that when?
On Thursday. So the date on that is going to be April 30th of 2026.
Okay. And that's just the one DNA report?
Correct.
All right. And that's only all the DNA reports, is that correct? Just from what she said?
As far as we know, and just for the record, Judge, that DNA report actually did have a date on it of February 26th, but the state, for whatever reason, didn't receive it till the 30th.
And so regarding that, Judge, I believe the reason for that is because technically the swab was taken from a crime scene where the defendant was shot himself and was considered a complainant in that case. And so there was no cooperation in that investigation, so the case was not turned over. There's no case pending with this defendant as a complainant, okay? And so the way that the system works, because it's tagged under that SAPD case number, it would not have come over under the SAPD case number associated with his murder charge.
And Judge, just to respond to that, back when Jason Gearhan was still on the case, we had that same issue come up on some other discovery that was discovered within this other case, and then it was turned over. So they were aware that there was some of this discovery applicable to our case that was in the case where he was the complainant on already.
All right. So is there any anticipation state that you will be using that DNA report for anything?
Judge, I'm ready for trial today, and if we proceed to trial today, I'm fine with the court expeding that. But if the court does grant the continuance, I would ask for consideration to include it.
Yeah.
So the state is saying they will not be using that DNA.
It's just that one report though, Judge, that was turned over on Thursday, because they've had the other two.
All right.
weigh in.
And we'll go through each evidence that you have step by step, but the state is saying that they will not be using that DNA. Is that still going to be an issue for the defense as it relates to that specific DNA? If the state says that that report, that one report, they were not going to be using it.
Well, until we
get it, we can't.
Yes, that's still an issue.
Okay. And then the next evidence.
So then regarding when the defendant was apprehended on his 7 warrants, the U.S. Marshals are the ones that executed those felony warrants. Judge, so when I came on the case, I was able to obtain one body-worn camera from the apprehension. When I spoke with the marshals about it, they told me that from that apprehension, there was only that one body-worn camera that existed, and so I did turn that over to defense. Now, where the issue lies is that I've been unable to obtain any reports from the U.S. Marshals. Okay, I did issue a subpoena to them, and I did just email them and ask them if anything is in existence, how fast they would be able to get that to me. And they, obviously the court is aware because TUI governs the federal government. They said that they're trying to obtain authorization and get it to me by the end of today.
All right. And then anything else?
And then on Saturday, I was made aware that regarding the crime scene where the defendant was shot, there is one body-worn camera from a sergeant that made the scene, and that was not turned over to me. I was not aware that it existed prior to Saturday. He tried to send me a link so that I could view it and download it. But the link that he sent me, I was unable to access it. So I did email him back and tell me that he needs to get it to me, and I've not received a response from him.
All right. So that's the only discovery?
That's the only discovery that I'm aware of, Your Honor.
All right. So where you say the crime scene where he was shot, is that in any way related to
yes, Judge.
What he's on trial for?
Yes, Judge.
Okay. All right. So this is what I want everyone to do.
Yeah.
I'm going to have you all come back at 2. And
That's
I
our
want to
time.
see where you all are with regards to this evidence. And then I'll make a ruling on whatever.
And the other evidence, Judge.
The other evidence?
Well, I led with the fact that we got on Friday interview notes from the state of interviews they did with witnesses. And those were the first time those witnesses were interviewed.
Okay.
So that's new information to us that our our investigator hasn't had a chance. Whether or not that we want our investigator to re-interview them, to talk to them, those types of things. And then the forensic DNA packet in its entirety, that was kind of part of the DNA.
All right. So I'll have you all come back.
Okay,
Yes.
if I could just respond really quickly. So regarding those witness statements, those witnesses did make statements to police officers on the scene. There was nothing that deferred from that. So, but I get what you're saying about if they want to re-interview. And then regarding the DNA package, I received that today, and I'm going to turn it over to them once they provide me a mechanism for that.
Okay. All right. So I'll have you all come back at 2.
Okay. 2
All right. Thank you.
Well, Judge, way to
All
leave
right.
us on the
And
hook.
Deputy Laura, if you'll put a hold on him.
We have to come back at 2. That was our case, and apparently we have some evidentiary issues.
All right. Who's next?
Derek Lopez, can you sweat for down?
Derek Lopez.
Oh, he dressed appropriately for court. Nice. He's a
All right,
tall
Mr.
fella.
Goff, what is happening with Mr. Lopez?
I believe today's our plea deadline day, Judge.
Yes.
And we have not received a plea that we're willing to accept. So at this point, we're asking the court to move us to the trial docket.
All right. If you will, how long do y'all expect this trial to last?
This trial,
Judge, this
as
one
opposed to
would, if
others.
guilt innocence, it would be about 3 days.
All right. So, Ms. Ferguson, 4-day jury trial setting, criminal trial division.
What does this shirt say? Is that
June 23rd.
Is that good for you, counsel?
Spotter. What?
No, I'm out.
Speeder.
Until July the 3rd.
All right.
SP5
Set it for the second week in July.
Thank you, Judge.
What date?
I'm guessing that shirt costs more than my entire outfit.
All right. We'll be back on July 14th.
Thank you, Judge.
You're welcome.
Downstairs?
Oh, he has a
I'll take
list
it
of
up
any
front.
case. Yeah.
Thank you, Judge.
All right. You're welcome.
I really appreciate it.
All right. You're welcome. Thank you.
Yeah, the judge doesn't need that view, sir. Hike those up. Pull those up. That's completely inappropriate. We don't need to see that. There we go. There we go. Thank you. You should have done that before the
6 on the second floor. Thank you.
All right. 2 o'clock Texas time puts us at 3 o'clock Eastern. So we can do a little court hopping before lunch, and we'll come back and see if the case is going to go forward with the jury or if we get pushed off on this one. Yet again, Judge Boyd has had a bad track record with us with some of the cases she's following. We pick a good case that she has, and it just doesn't get to trial in a timely manner. So we'll find out at 3 o'clock, and it's not looking good. It's not looking good. So, all right. We can't do the jury trial down in Texas with Judge Clark. So we've got to bail on that one. Let's see who else we have. Go back and see. I don't think. I think Darren Patterson's here in 13th. Hang on 1 second.
Do that until I have all the information first. So we're just asked that
There
it be
he is.
set over to a new court date and that the state start making headways to get the KHP video.
Yes, please get a head start on that KHP video as they do take so long.
Kansas Highway
And I'm going
Patrol.
to set this over at the defendant's request. Is July 27th the date you gave me, Jennifer?
Yes, Your Honor.
Mr. Correa, you must be back here July 27th at 8 a.m. You must be available to your attorney and give him any information that you need to. These are added conditions to the $1,000 bond you posted February 11th of 2026, which will continue with all existing conditions and the added ones today. Any questions about that, Mr. Correa?
Any questions? I'll just ask Mr. Darren.
All right. Just make sure you follow the court's orders. Thank you. You may
Darren's a
go.
smart man. He's a good attorney. He's got a lot of cases, though.
We'll now take up Idris on the record in BU 2025 CR 514, State of Kansas versus Bruce Leon Idris. Joseph Baca for the state, Darren Patterson for the defendant. Mr. Idris, are you here?
Yes.
Bruce Idris appearing in person as well. Any announcements?
Had some good beards.
Judge, we're asking this case be set for jury trial.
Very well. This matter will be set for jury trial, which is June. Remind me, Jennifer, please.
Jury trial is June 22nd. Jury beginning June 24th through 25th.
All right, Mr. Idris, I'm continuing this jury request to jury trial, which will be 9 a.m. June 24th and 9 a.m. June 25th. Prior to that, however, you must appear for the pretrial June 22nd, 8 a.m. Stay in touch with your attorney.
Okay.
You will be in recess at this time. You may go,
Thank
Mr.
you.
Idris. You're welcome. We'll now be
Regier
on
took
the record
vacation,
in Elam 2026 CR 92, State of Kansas versus Andrew Kyle Elam. Joseph Baca for the state, Jaron Patterson for the defendant. Mr. Elam, are you here?
Oh, he's here.
Yes, Mr. Elam appearing in person and pro se. Announcements on this?
Thanks, Judge. Judge, this is a case.
With a friend.
Cases where I need to meet.
Oh, then let me, yes, thank you for reminding me. We also are here on BU 2026 CR 92, State versus Andrew Powell.
I was not expecting
parties.
I was not expecting the blue.
Judge, this is a situation where I have reports. I just need to meet with my client to discuss those. I wanted to set a phone appointment with him while he's on here today to make sure we have that set. Otherwise, I'd ask the court to allow it to be continued one additional time.
State's response.
Judge, in looking at these cases, it doesn't look like we've had too much time pass. February between the two cases is probably the earliest start date. I would have no objection today. I do know Ms. Norris has an offer on the file. I believe Mr. Patterson might have that.
I have not. If you want to email that to me or have Ms. Norris email it, that'd be great.
I will certainly make sure that gets done.
All right, Mr. Elam, you must be back here July 27, 8 a.m. by Zoom. I will continue those as added conditions to your bond and be available to your attorney so we can resolve these at this time. July 27th, 8 a.m.
Greeners, I'm working on it with my stylist right now.
And Judge, I did want to provide this date to Mr. Elam also. Make sure you have this down. May 21, that is a Thursday. Thursday, May 21 at 9 a.m. I want you to call my office for me to have a consult with you, okay?
And I'm ordering it as
what day is that?
Thursday, May 21 and 9 a.m.
So call you at 9 a.m.
On that date, at that time, you call for an office appointment.
Okay.
Do you know the number to call?
He gave it to me earlier.
What is it?
It is, give me a second.
I can tell you it is 867-5309.
All right, I am making it a condition of that $5,000 bond you posted April 8th to 26 that you contact him at that date and time.
Yes, Your Honor.
And I'm also making it a condition of your bond that you reappear at the date and time for court I gave you.
That'll be a very expensive phone call not
what
to
day
make.
did appear at court?
July. You didn't write that down?
July 20th? Okay.
28th.
No.
July 28th.
July 28th. Okay.
Well, hold on, Jennifer. When is it? Say it again, please.
July 27th, Your Honor.
We all had it wrong.
July 27th at 8 a.m.
Had it wrong
Well,
too.
I usually write it down wrong, so I was double checking with Jennifer. You must be back here. Write this down. July 27, 8 a.m. July 27.
Put it in my calendar.
Okay, that'll work if you, as long as your phone keeps working.
Right.
July 27, 8 a.m. That should be a Monday, right, Jennifer?
That is correct, Your Honor.
And if you fail to appear for Mr. Patterson's appointment or for your court appointment, you could end up losing your $5,000 and having a judgment for $5,000 for that OR bond you posted back there in April.
Yes, Your Honor.
All right. If there's nothing further, you may go. Deputy?
Yes, Your Honor. Just for information, I was just going to pass along that I found out Carlotta Clark, that failed to appear earlier, is in Shawnee County Jail.
All right. Well, that's not an excuse, but thank you for letting me know. I wondered about that, but she has a duty to be here, and I can't check every jail in the state for it. Thank you, Deputy, for providing that. You might make a note of that, Jennifer, in the notes that she's, per deputy, she's in the Shawnee County Jail. We found out after court.
We'll put that in, Your Honor.
We'll still get that hold. All right, Mr. Elam, any questions?
No, Your Honor.
All right, you're excused at this time.
All right, thank you, Your Honor.
You're welcome. will be on the record now in Grunlock, BU 2025, TR 1441. Joseph Baca for the state, Darren Patterson for the defendant. Adrian Grunlock, are you present? Yes, you are. Thank you, sir.
With a child. For sympathy.
Any announcements on this case, Mr. Patterson?
Maybe take your hat off.
Yes, Your Honor. And Mr. Baca, I got your email, your text, or your chat message. I can't respond to let you know that, but what you have is fine. It's acceptable.
And I will let you know, Mr. Patterson, the message I sent you was on Clark.
Right.
What you sent on this one, I just wanted to point out, it seems like the request you made was for driving while suspended first. This appears to be a second.
Okay, just 2 minutes ago, I got a update from the court in Corey Richland's trial. Let's see, if you didn't get a seat, the pool, she's going to send out the link for the live broadcast. Ten people got seats.
Now, I don't think I saw the amended information, so that's got to be my fault. I don't have it
Park
on my
City
file
TV,
here.
the Park Record, KUTV.
Judge, in order to
Fox
get
13,
that
KSL.
resolved, I would ask the court either for a breakout room with my client
Nate
or
Eaton got a seat.
Well, let's see. The amended complaint has count 1, driving while suspended after prior, and improper driving on the left. So I'll give you a quick breakout room. We've got a lot to cover. Mr. Grunlock, look on your screen for invitation to a breakout room and click on that. Clerk Jennifer, if you please put Mr. Patterson and Mr. Grunlock in a breakout room. Thank you. How about Sun Hong Nguyen on the record in BU 2025 TR 2197?
Yay! He's here!
State of Kansas
Mr.
versus
Regier.
Sun Hong Nguyen.
Hello!
Jared Regier for the state. Is Mr. Nguyen present? Defendant fails to appear on a motion.
Bench warrant. Bench warrant. Throw the book at him.
Mr.
Just in honor of Mr.
Regier,
Regier.
state's response.
Your Honor, this is a case where it would appear that the defendant previously failed to appear 2 times consecutively in September of 2025 and December of 2026. And in December of 2025. According to my office, did file a subsequent motion for judgment on bond in February of 2026. There appears to be an affidavit of service by certified mail filed in March of 2026 with respect to the bondsman, indicating, quote, on February 23rd, 2026, the motion for judgment on bond was delivered. State's information is that there was an attempt at service by mail to the defendant as well back in February, although I am not showing a return on file in that matter. As to the defendant on the motion for judgment on bond on file with the court at this time, nevertheless, the state's position is that the motion for judgment on bond should be granted and therefore moves the court to proceed in that fashion.
Are you proceeding on that $1,000 bond posted September 22nd to 25? I see he had a prior one for $5,000, but it looks like the bondsman was released on that one March 11 of 26.
One moment, Your Honor. Your Honor, the state's information is that there were 2 previous bonds in this case. First by both which appear to be professional surety bonds signed by Dynamite Bail Bonds, $1,000 and $5,000 respectively. The state's information is that the motion for judgment bond does specifically refer to the $5,000 professional surety bond in paragraph 2 of the same.
Well, somehow the bondsman finagled his way in and got a release on that March 11 of 26. So I think we're going to have to go after him on that 1,000. I try to make them get a signature showing the county attorney's position on those. but I'm not always successful in getting that. So I'm going to have to deny that one, but if you want to try on that other one, I will certainly entertain it. And if you review that and disagree that he's been released, you can certainly bring it back before the court's attention.
If that is the court's order, my office will prepare appropriate paperwork, Your Honor.
Okay, thank you, Mr. McGee. We'll take up Connor Porter. On the record in 2025 TR 2128, State of Kansas versus Connor Douglas Porter. Jared Regier for the state. Defendant, are you here, Mr. Connor Douglas Porter?
I am present, yes.
Start your video.
I'm trying to figure that out. I can't find it.
If you can't figure out your video, you've got to be at the courthouse. Otherwise, I don't have any proof that you're here.
I figured it out.
Okay, there. You're Connor Porter, is that right? Connor Douglas Porter?
Yes, ma'am.
All right, you were here December 3rd, said you were going to hire an attorney, so I continued your bond to give you time to do so. You were here February 9, 2026 without an attorney, but we set this over to give you more time to get an attorney, but you're here May 4th without an attorney?
I'm just going to waive my rights to an attorney and represent myself.
Oh, goody.
You understand you do have the right to hire an attorney, and if you cannot afford to hire an attorney, you can apply for a court-appointed attorney and see if you qualify.
I will not qualify, make too much.
Make
All right,
too
so
much.
you
Then
are
you should probably
exercising your right
pay
to
for an attorney.
represent yourself without an attorney.
Yes, ma'am.
Anyone making you give up your right to an attorney?
No, ma'am.
No one threatening you or promising you anything if you do?
No, ma'am.
I will have the record reflect both in the journal entry and the docket notes that the defendant, Mr. Porter, has knowingly and voluntarily given up his right to an attorney or waived it. How do you wish to proceed then on these charges? Count 1, driving while suspended after a prior conviction. Count 2, reckless driving. Count 3, ignition interlock violation. Count 4, no proof of liability insurance.
Well, there was no insurance, so I plead guilty to that, and I was hoping to drop the driving on suspended and maybe drop the reckless to careless.
No, that's not up to me. At this point, that would be up to the county attorney. Any comments on that, Mr. Regier?
Good luck.
Your Honor, for the limited purpose of resolving this matter today, the state would be prepared to dismiss count 1, driving while suspended, a Class A misdemeanor, in exchange for a plea as charged to all remaining counts.
Ooh, you got a deal.
So that would
through.
mean no dropping the reckless then.
Yep.
No just dropping of the reckless, just the driving while suspended after subsequent conviction of Class A misdemeanor.
Okay, I'm okay with that.
All right, so how do you plead to count 2, reckless driving?
Guilty.
How do you plead to count 3, driving with violation of your ignition interlock restriction?
Guilty.
How do you plead to count 4, driving without proof of liability insurance?
Guilty.
Anyone making you enter these pleas of guilty today by any threats or promises?
No, Your Honor.
I understand you will be found guilty and proceed with sentencing today.
Yes.
All right. I find you know what you're doing and that you've voluntarily entered these pleas. I find you guilty of counts 2, 3, and 4 and dismiss count 1 on motion of the state per plea agreement. Sentencing recommendations, Mr. Regier.
Your Honor, the state is confirming one final matter. If the court will grant the state 1 minute.
Certainly.
Please wait while Mr. Regier downloads the latest information. Connection established. Download initiated. Download complete. Processing. It's a lot of processing. I like watching him think. He's buffering now. Hold, please. There we go. Decision reached. Confirm your metrics. Checking hash values. Authentication complete. Exporting results. Encrypting results. I don't know what he's doing here. He's taking forever. He's taking his full minute. He never takes his full minute. Even Judge Webster's like, you only asked for 1 minute. This is Mr. Regier in his
Mr.
home
Regier,
habitat.
did you need a few more minutes?
Thank you, Your Honor. The state is prepared to proceed, if I may.
Yes, please.
Your Honor, with respect to count 2, the state would be recommending a $100 fine, that the court impose appropriate court costs, and a 90-day suspended jail sentence. For count 3, a $100 fine and a suspended jail sentence of 12 months, as it is a Class A misdemeanor. For count 4, the minimum fine required by law of $300 and a 6-month underlying sentence. The maximum permitted for a Class B misdemeanor. The state is not opposed to the court running those concurrent if the court deems that to be appropriate. However, for a controlling sentence of 12 months, however, the state is recommending a year of reporting probation subject to all standard conditions, including a $60 probation fee and any other orders of the court may deem appropriate. The state's information is, if the court will accept a proffer, is that this is a defendant who has been previously convicted of both driving while suspended and DUI pursuant to the certified driving record within the last year. So the state's position is that a 12-month reporting probation is appropriate.
Thank you. Mr. Porter, anything you want to say before I determine your sentence?
Nope, I was prepared for that.
You got me.
All right, at this time on count 2, you're sentenced to $100 and 90 days. Count 3, $100 and 12 months. Count 4, $300 and 6 months. Where do you work?
I work for a Smoky Hill Construction out of Salina, Kansas.
All right.
Worked there for almost 4 years.
Very well.
And I make $90,000 a year salary.
All right. Your court costs are $108, and your supervision fees are $60 for a total of $668. You need some time to pay that? Or
No,
are
I
you-
can pay that right now. I
Are
can
you-
call
are
the county clerk or whoever I have to right after this and make that payment.
All right. I will run all your sentences concurrent, so if you violate your probation, the total will be 12 months that you have to actually serve. Your probation is for 1 year. You do have to report to probation. Call them at 316-322-4153 to report.
Okay, can I say that one more time?
Sure, 316-322-4153. And you've got the clerk's number to call to set up your payment arrangements.
Okay, so that was for probation and clerk. I am ready for that number.
That's 316-322.
Lots of numbers. 8675309. Just excited to be back with Mr. Regier.
Online, and they will give you the online site, but you'll probably need us to get the journal entry on file. That might take up to 30 days before you can do that.
So do you suggest I wait the 30 days or can I try tomorrow?
I'll call the clerk and see what they suggest, and then Mr. Regier's usually pretty good about getting that journal entry pretty fast, so maybe
So is that something I should do this afternoon or should I give him couple days to
Why don't you
file
give
that?
it a couple of days?
Okay, I
Couple
can.
days is good.
Okay, I can do that.
All right. Thank you then. Is there anything further from either party?
Mm,
Hearing nothing, we'll be in recess.
Forgive me, Your Honor.
Oh,
Two final matters.
okay.
Your Honor, is the court ordering that the balance of this case shall be paid in full today or some alternative time frame, given the court's orders?
Oh, let's give it 30 days since we've got to get the journal entry on file.
I'll pay it as soon as I get clearance to pay it. I'll be sure to call in the next couple days, see where we're at.
And Your Honor, as the court is well aware, there is the prospective possibility of certain administrative penalties for these kinds of convictions pursuant to statute. The state does not have anything further.
All right. Well, I don't have the power to suspend, but on this case, but do keep your address current with Department of Revenue in case they put any penalties on you for these convictions.
Yes, ma'am.
All right.
Thank you.
You may go.
Have a good day.
You too.
Thank you.
Uh-huh. Okay, we took up Clifford Rhodes and Connor Porter. Are we ready to go back to yours, Mr. Patterson?
Yes, Your Honor. Adrian Grunlock.
Okay.
Adrian has
Back on the record
negotiated.
in BU 2025 TR 1441, State of Kansas versus Adrian Justin Grunlock. All parties appearing as before. Joseph Baca for the state, Darren Patterson for the defendant, who is also in person. Mr. Patterson?
Judge, I have had an opportunity to talk with my client about the amended information, driving while suspended second, or driving while suspended after previous conviction. To that charge, my client will enter a plea of guilty. State's agreed to dismiss count 2.
All righty, that's your plea agreement, Mr. Baca.
Your Honor, that is correct.
Mr. Baca, can you send back Mr. Gear?
And that is pursuant to the amended information. So at this time, you said he's pleading to count 1.
Yes, Your Honor. Guilty.
Mr. Grunlock, count 1, alleging that on June 19th of 2025 in Butler County, you did unlawfully operate a motor vehicle upon a highway of this state while your privilege to drive was canceled, suspended, or revoked after having been previously convicted of driving while suspended, to wit on the 16th day of May 2024 in Wichita Municipal Court, 24 TM 5675. How do you plead?
I plead guilty, ma'am.
By pleading guilty, you're admitting that you did do the act alleged of driving while your license was suspended?
Yes, ma'am.
And it was on June 19th of 25 in this county, Butler?
Yes, ma'am.
That you did have that prior conviction in Wichita?
Yeah.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, ma'am.
You understand you're giving up your right to trial. You'll be found guilty and unable to appeal your conviction.
Yes, I understand.
Then I find that you are knowingly and voluntarily entering your plea of guilty to count 1. I find you guilty of count 1 and dismiss count 2 on motion of the state for plea agreement. Sentencing recommendations, counsel?
Your Honor, at this time, pursuant to joint recommendations, and I'm sure Mr. Patterson will correct me if I get any part wrong, we are recommending the $100 mandatory minimum fine, 8 months jail suspended, recommended 1 year non-reporting probation. Your Honor, state would not object. I believe the defendant's going to make a request to serve 10 days house arrest in lieu of the mandatory 5 days jail. Would also request court costs and the court to determine attorney's fees.
Mr. Patterson, that's your agreement?
It is, Your Honor. We would ask the court to consider the 10 days house arrest with work release. In this case, he is employed, and keeping that job to him is very important, I think, for his well-being going forward, keeping that job. So we'd ask the court to allow that, please. Thank you.
All right. Where do you work, Mr. Grunlock?
I work at All Parts Auto Salvage. I have a 6-month-old daughter, and I'm the only provider in my house, so that's why I just want to see if I could just do the 10 days.
Okay. I will waive the attorney fees, but you are fined $100 and assessed $108 court costs. How much time do you need to pay that 208? With 30 days, 60 days?
Could I get 2 months on that? 60 days, please.
60 days to pay. Your jail sentence is 8 months. If you do not want to serve that 8 months, make sure you successfully complete a 1-year non-reporting probation. You are going to have to complete a 10-day house arrest as part of that probation. Okay, when do you want to check in to start that? Well, when do you want to hook up the electronic monitoring? When do you want to hook that up? Can you do that?
Can I start it next week on Monday?
A week from today, Monday would be great.
And I'll do it through the Wichita Bonding Company.
As long as you do it by a reputable company and provide proof to your attorney and the county attorney.
All right.
All right. So you're going to begin that you want to start that at 9 a.m. Monday?
Yes, ma'am.
And you will be granted house arrest, but no more than how many? Do you work more than 40 hours usually?
I work anywhere from 40 to 45 every week. I work 8 to 5 every day.
All right. You'll be allowed to work your normal hours, but don't be adding in more just to avoid house arrest. And so condition 1 is your 10-day house arrest. Condition 2, don't violate any laws. Condition 3, pay within 60 days. Anything further, Mr. Baca?
That's all.
Judge, I don't believe there's anything further from the state.
Seafood gumbo.
Mr. Patterson,
Never
anything
had
further
it,
from the defense?
but I need
Nothing
to try.
further, Judge, except was he gave him the phone number, but he's got to use Wichita bonding, so I'll leave that to him.
All right. Don't blow it or you're going to be away from that baby for a while.
Chewy Baca.
Oh, I won't blow it. I can't do that.
There you go.
I'll make sure I get it all taken care of. I'll
right,
call them and get my appointment with them today.
And not just enough to do it. You have to get proof over to the county attorney and your attorney that you've done it.
Okay.
All right. Thank you.
Okay,
I
I can give the Inco company my attorney's information.
Very good. All right. You may go, sir.
All right. Have a good day.
You too. We'll now be on the record in Kiefer 2021 TR 2418, State of Kansas versus Allison Ann Kiefer. Joseph Baca for the state, Darren Patterson for the defendant. Allison Ann Kiefer, are you present?
Judge, I can tell the court that I have not had any contact from Allison Kiefer. I have no explanation of why they're not here today.
Mr. Baca, any recommendations? She's got a list of charges here.
Yes, Judge, I have not heard anything in our office about her non-appearance today. It does appear there was a prior failure to appear that occurred back in 2023, October of 2023. And here we are again today. I think the bond she was on was $2,000. So state's request at this time would be a bond forfeiture, request a bench warrant. In looking at the charges and coming up with a recommended amount, state would recommend at least a minimum $4,000 cash or surety bond.
Old as this case is, failures to appear, bond forfeiture, bench warrant, $5,000 cash or surety required.
Yes, Your Honor.
We'll now be on the record in Llewellyn 2025 TR 188, State of Kansas versus Shane J. Llewellyn. Jared Regier Joseph Baca for the state. Darren Patterson for the defendant. Is Shane Llewellyn here? Defendant
Judge, I have not seen Shane Llewellyn here today. I don't have an explanation whether or not here. I haven't had any other contact.
Recommendations from the state?
Yes, Your Honor, we've had no contact either. It does appear, once again, there was a prior to failure to appear on this as well back in July of 2025, and that brought the bond up to $2,000. I think based on the non-appearance here today, state would request a bond forfeiture bench warrant, request a minimum $4,000 cash surety bond.
Bond forfeiture, bench warrant ordered, new bond set, $4,000 cash or professional surety. will now be on the record in Marcotte. On the record in BU 2026 CR 48, State of Kansas versus Sean Bubba Marcotte. Joseph
Mayor.
Bach for the state, Darren Patterson for the defendant, who also
Bubba.
appears in person. And pro se,
Bubba and
Mr.
Baca.
Patterson.
Judge, this is a case where the order of appointment was filed April 29, and the discovery through the county attorney's office was authorized or for us ready to download April 30. We haven't had time to prepare a file in this case yet, so we're asking it set over. Would also ask that Mr. Marcotte make sure that we have all current contact information so that once we have everything, we can reach out to him and get a time set up to discuss the case.
You want him to call your office in the morning then? Or?
Tomorrow morning, please, since I don't have anybody here answering the phone currently.
All right.
Darren Patterson is a
Mr.
one-man show
Marcotte,
today.
I'm going to set this over to, I believe, July 27, 8 a.m. Jennifer, is that what you want?
That is correct, Your Honor.
All right, Mr. Marcotte, you are ordered to reappear by Zoom July 27th at 8 a.m. You are also ordered to contact Mr. Patterson's office in the morning and talk to his people live. Give them your contact information and whatever else they need. This is going to be conditions added to your $5,000 surety bond posted January 25th of 26. Mr. Baca, anything further on the Marcotte matter?
Nothing further from the state, Your Honor.
Mr. Patterson, anything further?
Nothing further, Judge.
All right, Mr. Marcotte, you are excused from today's proceedings and you may go, sir.
Thank you.
You're
Aaron
welcome.
Blackman
Thank you.
says, all right, had to
Your
take a
Honor,
trip
may
up
I
to
interrupt
Norfolk
for
this
1
weekend.
second?
Sure.
My
Stopped in for
my
gas.
flag. Can I get the bond on Llewellyn?
I'm going to mute them for a second while they fix the paperwork notes. Stopped in a gas station. The first thing I saw was Deer Park Water. Thought about the channel, the community. Happy Monday, everyone. Aaron, hope you got a drink. Not a sponsor yet. But might be.
On your list.
Yes, Your Honor.
Mr.
Okay, on the
Aguirre's
record
back.
in BU 2025 TR 2660, State of Kansas versus Richard Ned Shearer III. Jared Regier
third?
for the state, Darren Patterson for the defendant.
How does the second and the
Richard
first feel
Shearer,
about
are
the
you
third
here?
picking up a
Richard
charge?
Shearer III. Looks like he fails to appear. Counsel?
Judge, he was here early. Oh, he's on here. Mr. Shearer, make sure and turn on your video and unmute, please. It's under Rick Shearer, Judge, the
I do
big
see that.
R.
I see that now. Thank you.
Rick Shearer, please turn on your video.
If you're on a telephone, run your finger down the side of the bottom of your phone and a little red microphone with a line through it and a little red camera with a line through it should pop up. That's if you're on your telephone. Your computer, there's probably something at the bottom of the screen that talks about start video or start audio. If you're hearing us, Mr. Shearer.
I am asking him to unmute and to start his video.
Thank you.
I think he stepped away. Hello, Rick. You're about to get a bench
Well,
warrant.
let's move on to Simons. On the record in BU 2026 CR 38, State of Kansas versus Chelsea. Leanne Simons, Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Now, Mr. Patterson, I showed this as a preliminary hearing, and I don't think it is. So,
No, Judge, this is a case misdemeanor, domestic violence, battery. We're asking to have it set for jury trial, but also we're asking the court to take up an issue concerning bond.
all right, jury trial, Jennifer, if you'd give me those June dates again.
June 22nd for pretrial, June 24th and 25th for jury.
Okay, Ms. Simons, you are ordered to reappear June 22nd for pretrial conference. You are ordered, and that will be at 8 a.m. by Zoom. You are ordered to appear live in person for jury trial at the courthouse June 24th and 25th. We'll start promptly at 9 a.m. And
We'll see
And
then.
Judge, this is the case I sent an email to court and counsel on this morning that had a copy of a counselor's report.
I know you had several things over here for me. Let me see what I can find.
Wait for it.
Mr. Regier, did you see it? I'm just trying to make sure it was sent.
Your Honor, is the court on the record in this matter?
We are.
Your Honor, the state is not aware of having received any updated documentation regarding this matter as of right now.
Well, let me try searching for it.
And I apologize. I think my office might have missed this before she left, so I'm sending it out right now.
May I ask what case we are on?
This is on Chelsea Simons, 26 CR 38.
We're going to jump up to Thurston, Washington.
You're welcome.
Ready?
One matter looking like it's ready to go this morning. That's a matter of Miles Cruz, as well as two change of pleas for Melanie Glenn. Let's begin with Melanie Glenn, if we will. I see Melanie on Zoom.
Hey, Melanie. Welcome.
Right. And Mrs. Groth, good morning.
Good morning, Your Honor.
All right. And you're representing Miss Glenn, is that right?
Yes, Your Honor.
This is a jury trial coming up here in just a minute after this.
There it's
And Miss Glenn?
From the Holiday Inn Court.
Yes.
And let's see, do we have a prosecutor for the county? All right. Ms. Groth, do you know who the assigned DPA is on this matter? Doesn't look like we have a county prosecutor.
It is Mr. Clark, Your Honor.
Do we know if he's over in one? Okay. All right. Ms. Glenn, your patience is appreciated here. Before we move on to your changes of plea, we're going to have the assigned deputy prosecuting attorney make sure he's in the right courtroom so we can proceed. All right? Okay.
It froze.
Let's see. While we're waiting on Mr. Clark, we've got parties present for Miles Cruz. Good morning, Mr.
Good
morning, Your Honor. And Ms. Pinkston, good morning.
Morning.
All right. And so is Mr. Cruz still over at Nisqually for this morning's piece of it then?
No, Your Honor. My understanding is he is in the building.
Okay.
I have not laid eyes on him yet, however.
Okay. But, so you haven't had a chance to speak with him this morning?
Correct.
Do we know where is it? Okay. Okay. Do they keep folks in a particular place usually? Okay. Okay. Miss Pinkston, do you know where the Nisqually folks are keeping Mr. Cruz?
I don't know where they keep them here.
Probably.
But I can text the officers that should be with them.
Somewhere secure.
Okay. And then let's see. And then Mr. Taylor, are you going to want some time to speak with Mr. Cruz before?
Yes, Your Honor. I think they might be bringing him in. Right
Oh, okay, wonderful. All right. And you said you would like a few moments to speak with Mr. Cruz.
Yes, sir.
Okay, that's fine. And then officer, so is there a place where Mr. Taylor can meet with Mr. Cruz?
Sure.
No, okay.
Mr. Cruz off. Or have him come in here.
It sounds like you'd like a private meeting with, yeah.
when we toured this building a month ago,
Yeah.
there was a room upstairs.
Yeah.
But the DPAs had locked it and
Yeah.
Heather didn't have access to it.
Okay.
So that's the only room that I know of.
Right. Okay. Is the room where he's being held right now, is that place? Okay. Okay. That sounds good. Thank you.
Thank you.
And then what we'll try to then resolve is if we can get Mr. Clark here for Melanie Glenn, we'll resolve that change of plea. Okay. All right.
Your Honor, I just messaged Mr. Clark. He'll be on Zoom in a few minutes.
All right. Thank you.
Well, we can speed forward.
So we let Ms. Growth know. So I see you still on Zoom there, Ms. Growth. It doesn't look like we have any change of plea or any kind of resolution document in the file.
I think we're waiting for the PAO signature. I checked Laserfish. It is still in their folder, so I don't know if they've signed it yet.
Got it. Okay. Thank you. I just figured we could resolve that if we were. Thank you.
Yep.
Thank you for being here.
This happened just a couple of minutes ago. We're trying to catch up. Where's the other dude?
Mr. Clark. Great. Okay. When we take up a case, I just wanted to troubleshoot any other issues we may have, but it looks like we've got audio, so should only be a few more minutes. Thank you for your patience.
Okay. Thank you, Judge, for
Okay, thank you.
giving us updates. Still waiting. Wait for the judge to come back. Here he is.
Back in session. All right. First, we're going to address the Melanie Glenn matter. Looks like we've got DPA Clark present on Zoom. Good afternoon, or good morning, Mr. Clark.
Good morning, Your Honor. Sorry about the my lateness.
It's all right. Okay. Got Attorney Growth, and we've got Miss Glenn.
Yeah. And Your Honor, the plea form should be signed and in the judge's folder.
Thank you. And I do have a form in front of me. All right. All right. So, Miss Glenn, I do have in front of me a document titled Statement of Defendant on Plea of Guilty, in which you're agreeing to plead guilty in matter ending in 335 to the charged crime of driving under the influence, a gross misdemeanor punishable by up to 364 days in jail and a $5,000 fine. Do you feel you've had enough time to review this document with your attorney?
I have.
In paragraph 5 of that plea form goes over certain important rights you're agreeing to give up by entering a guilty plea. Do you have any questions about your rights?
I do not.
There's an agreed recommendation. That recommendation is to suspend all 364 days jail for a period of 60 months. During that period of time, there'd be certain conditions of probation. I won't go over each of those here, but the affirmative conditions would be to get a substance use evaluation, follow up with whatever treatment program is recommended, as well as attend the DUI victim impact panel class. Is that your understanding of the agreed recommendation?
It is, and I have completed the victim impact class.
Okay. All right, very good. Well, and do you understand that that is just a recommendation to the judge? Judge does not have to follow it, but could set into penalties for DUI, which I went over there a moment ago. And if so, that's not a reason for withdrawing your change of plea. Do you understand that?
Hmm.
Is that a yes, ma'am?
Yes, sir. Yes, sir.
box has been checked here on the plea form that you have been advised that if you are not a U.S. citizen, a criminal conviction may carry adverse immigration consequences. Any questions about that, ma'am?
Nope.
I see the box has been checked that you've been advised about the mandatory minimum period of time that your license, driver's license, would be suspended as a result of this conviction. The minimum period is left blank here on the plea form. I believe, looking at your history, that would be a 90-day, inclusive of any time it's been suspended while on pretrial status. Do you have any questions about that, ma'am?
I don't.
I also see the box here has been checked. Penalty attached to it. Is that right, ma'am?
I'm sorry, you were cutting out.
The box is checked on the plea form that you've been advised about the penalties that attach to a DUI conviction. Do you have any questions about that?
You're still cutting out because my attorney's
Has
in a
anyone
noisy
made any
office.
threats or promises to get you to change your plea?
No.
Provides a statement of fact used to support that change of plea. I'll read you that statement and ask you if it's accurate. And that statement reads that I, at the time of driving a motor vehicle, had sufficient alcohol in my body to have an alcohol concentration of 0.08 or higher within 2 hours after driving, as shown by an accurate and reliable test of the defendant's breath. This act occurred in Thurston County. Is that an accurate statement in your own words?
Yes, it is.
All right, Ms. Glenn, to that charge of driving under the influence, how do you plead, guilty or not guilty?
I'm guilty.
I find Ms. Glenn's plea of guilty to be knowingly, intelligently, and voluntarily made with an understanding of the charge and consequences of the plea. And there's a factual basis for the plea. All right, so ma'am, what happens? I'm going to sign the plea, turn it over to the attorneys to talk about the agreed recommendation. You'll have a chance to address the court before sentencing if you wish. You don't have to say anything, though, if you don't want to. And I'll start with the prosecutor, Mr. Clark.
Yes, Your Honor. The state is asking the court to follow the agreed upon recommendation. The state believes it is a fair and just resolution to this case.
Thank you. And as part of this agreement, then is the state moving to dismiss the, I believe it was reckless?
Yes, Your Honor.
Reckless endangerment, the matter ending in 3-2?
Yes, Your Honor.
All right, thank you. And Ms. Grove?
I would agree with the prosecution, Your Honor, and I would also like to say that Ms. Glenn has informed me that she has no intention of drinking again. She has a liver condition that would prevent her from drinking again, and she is looking into mental health options to help her stay sober.
Thank you. And it sounds like I heard she had compared back panel already. Ms. Groth, do you happen to have that documentation?
Yes, I just sent that to the court this morning, Your Honor, so it should be filed shortly.
Well, thank you. All right. Well, Ms. Glenn, this is your opportunity to address the court. If there's anything you'd like to say, again, you don't have to if you don't want.
No, I mean, this has definitely been an eye opener for me, and and I apologize for anybody that I could have put at risk, or that I did put at risk when I decided to drive under the influence. I've got over 6 months sober now, since that night, and I continue, looking forward to many, many more. So thank you.
Thank you, ma'am. Well, I will follow the agreed recommendation. As to the DUI conviction, impose 364 days jail, suspend 364. That's going to be for a 5-year period, so through May 4th, 2031. During that period of time, the conditions of probation include to not commit a criminal offense, to not drive without an ignition interlock device per DOL requirements, to not go to any bars or taverns, to not drive without a valid license or insurance, to not consume any alcohol, marijuana, or non-prescribed drugs, to not refuse a UA or a breath test when requested by law enforcement. Sounds like you did the victim impact panel already. Have you made any progress on getting a substance use evaluation, or know where you're going to go do that?
I think I'm going to go to Providence because that's where I was going before, and they know my situation when it comes to my mental health and my recovery. So,
very good. Well, and I know Providence goes to the Thurston County Resource Hub, I believe Thursday mornings as well. So that's for substance use evaluations. All right, ma'am. So I'm going to put you on active supervised probation because it sounds like you've already made some initial efforts, which is wonderful, on complying with probation and getting some of that done. Probation counselor will be a resource to help you with the rest of the process as far as getting that evaluation completed. And then really, I think most importantly, understanding that evaluation because the recommendations in that evaluation automatically become your conditions of probation as well. So a lot of that responsibility falls back on the individual to understand that treatment recommendation and enroll in that program and make sure paperwork demonstrating compliance gets to the court and all of that. And probation is there to help you with that. As you won't be necessarily, that doesn't mean active supervised probation for 5 years. If you've got demonstrated compliance and it looks like you know what you should be doing, that supervision does taper off. But they're there as a resource for you, at least at the beginning. So you'll be on active supervised probation. That means as you will have 48 hours to contact probation. I'm filling out a judgment and sentence form. This has the conviction, the conditions of probation on it, and probation's phone numbers on this form. So you can get a copy of it off the Thurston County District Court website. I'm sure Ms. Groth would also be so kind as to send you a copy if you need it. But probation's contact information is on there. Finally, affirmative conditions of probation do include getting that substance use evaluation and following up with treatment, as well as the victim impact panel. Sounds like you've done it. So as far as that goes, you'll need to, it sounds like Ms. Groth actually is sending that over to the court. So that's going to be on there as a condition, but as soon as that's in the court file, that condition has been satisfied. All right. Do you have any questions, ma'am?
I do not.
All right.
So wait, I do. So active supervision, what does that mean? What does that entail?
So that I think the most important thing to keep in mind at this point is the phone number on the judgment and sentence. That's probation's office number. Just call them within 48 hours. They'll help explain the rest of the process. They're going to set up another time for you to come in and meet with them. They're going to see what you have to do on probation, and they're going to essentially be there to help you stay compliant. And so that's the role. So yeah, most important though, contact them within 48 hours. Out of the $5,000 fines or fees, I'll waive all but $240. That's a probation cost. It goes back to probation that assists in your supervision. You've got the 60 months to pay that off. If you'd like to work out a payment agreement, you can contact County District Court Clerk's office, or you can pay that all up front if you wish as well. But there will be that $250 fee. The rest will. All right.
Okay.
All right.
Thank you.
Ma'am, you are free to go.
All right. Thank you.
Oh, I'm sorry. And before you go, no, I'm sorry. I spoke too soon. We'll be also states move to dismiss matter ending in 432 per the plea. That's that reckless endangerment charge. So I'm also filling out a judgment and sentence form showing that it's dismissed.
Okay, perfect. I appreciate it. Thank you.
Ms. Glenn. And thank you, Mr. Clark and Ms. Groth.
Thank you, Your Honor. Have a good day.
Thank you.
All right, with that out of the way, we may have jury selection, a little trial here.
All right.
Are we ready, Judge?
So now let's see, turning to matter 2026-022, Miles Cruz. Good morning, Mr. Cruz.
Good morning, Your Honor.
All right.
So we're here 022, Your Honor.
I'm sorry. 022. I'm sorry if I misspoke there. 2026-022. All right. So we're here for jury trial. I have in front of me motions in limine filed by both parties.
Lots of lemonade.
I'll start to see if there's any that are in dispute or that the other party wants to address explicitly. I guess we can start with the plaintiff in the case, City of Olympia, Ms. Pinkston. If there's any defense motions in limine you'd like to address.
agreed to, except for defense number 2 as well as cities number 2, I think correlate. And so it's probably going to be the only one that there's an argument about. I believe the other ones. We don't anticipate bringing in any statements from when he was in custody. I don't have any visual aids that I anticipate showing the jury. He won't be wearing restraints. We only have one witness, and that will be a law enforcement officer. So there'll be no one else to exclude from the courtroom. I agree with an alternate juror. So I think those are all agreed.
All right. And I similarly expected maybe numbers 2 on each filing to be discussed. Mr. Taylor, any understanding we'll talk about motion limiting number 2. Any others you'd like to address specifically?
No, Your Honor. That's the only one of the cities that I think getting clarity as to what the court intends regarding the voir dire process would be helpful.
As far as the timing and all of that?
The timing. Yeah. So without knowing what the court's plan is, it's hard to know whether I'm joining or just not taking a position on the city's request.
All right, yeah. Okay, so let's address that one. I understand the 15 minutes. We don't have any kind of 15-minute policy. That's sort of judge by judge. And actually, I should step back saying the word judge. I'm not a judge. I'm a commissioner. And with that, I do need the party's permission to hear a jury trial case. That's one of the aspects of commissioner. So I'll start with the city. Any objection to me hearing the case today?
No objection.
A defense?
No, Your Honor. I discussed it with Mr. Cruz. We are consenting to Your Honor hearing this trial.
Okay, thank you. That in mind. So my experience has been a little bit longer than the 15 minutes. I typically default to 30 minutes for everything, for jury selection, opening and closing statements, unless there's a request for more time than that. I know, Ms. Pinkston, this was your motion. Does 30 minutes sound sufficient?
Yes, that's
okay. All right. So we'll do 30 minutes for each. So that will be questioning the panel, opening and closing statements.
Is that broken up into 2 segments of 15 or 1 segment of 30 or something else?
Well, that's really up to you. I think if you want to break it up into 2 segments, I think that's fine. It's more about time management. So it's just 30 minutes total. If would you prefer to have that broken up?
I would prefer to have it broken up simply because sometimes things come up during one attorney's questioning that might prompt a follow-up question from another attorney, and having more opportunities to make that happen that are baked into the expectations seems like a good idea.
Okay. Any objection to that, Ms. Pinkston?
No, the way that I've typically done it in the past is if we have 30 minutes and you can use as much time as you want. And then if you have 5 minutes left to ask follow-up, then you have 5 minutes left. So I'm fine with that.
All right. Yeah, that's my experience as well. So you've got the 30 minutes to work with. You're free to break it up however you wish. All right. So on motion in limine's sort of number 2 here. So in this, the charge, given the nature of the charge here, of obstruction of a public servant or officer, one of the elements is that the officer was discharging their official duties, and that the defendant knew about that. And I'll certainly hear from defense. My thinking on this is that there does need to be some evidence, or the city should be allowed to present some evidence for the reason of the public servant, in this case, the Olympia police officer, approaching Mr. Cruz, and what that duty entailed, what made it part of the official duties, and whether that was communicated to Mr. Cruz. That sort of evidence would necessarily be part of the city's burden of proof in making their case. So I do think that if the city has some evidence as to the active warrants to present, then that is part of their case. My thinking though would be, and I believe the city even offered this in their motion in limine, that there would be no details as to the allegations for the cases underlying the warrants, what the warrants were for. I don't want to speak out of turn for the city. Maybe you'd like to address the limitations, Ms. Pinkston, that you would put on that.
We don't have any intention of bringing up what active warrants were in the system at that time, or what the law enforcement officer, any details that he would have known about those warrants, for if they were arrest warrants for failing to appear or new charges. None of the amount of them, none of that will be asked. It'll just be that he had knowledge that there were warrants in the system. What did that knowledge then make him do, which was approach and give warnings to the defendant? And that would be the end of the discussion of the warrants when it relates to Mr. Cruz.
Okay. All right, thank you. And Mr. Taylor?
So, Your Honor, I think maybe I wasn't clear. I did file a response. I don't know if the court reviewed that. The issue is not whether or not it is relevant. I agree that it is if there was a fact of a warrant. The issue is more of a discovery violation. Ms. Pinkston just referred to warrants in the system. There's been no discovery provided regarding the existence of specific warrants or copies of them, or any information to lay the foundation that the system was functioning properly. Additionally, my understanding is that the way this often works is that there is a call placed to dispatch, who then reviews the system, which would introduce a layer of hearsay. So my objection really is not about whether or not this type of evidence may be admissible. It's more about whether or not the city can establish the foundation for its admissibility. And that's why I phrased it as a response, but also as a separate motion in limine.
Okay. Let me see. When was this filed, Mr. Taylor?
My response?
Yeah.
I attempted to file it Friday afternoon, about an hour and a half after receiving the city's motions in limine.
Okay.
Friday afternoon.
Thank
I
you.
can provide the court a bench copy.
I think that would be. I'm not seeing it in the profile. It may have not gotten in there though if it was Friday. Okay. Yeah, that's fine. Thank you. All right.
Let's hear about the warrants, or the lack of warrants. What says you, Judge?
So thank you for providing that. So my thinking here is that if Mr. Taylor, if you want to object to the officer's testimony as to the foundation of the warrant, that's something that you can object to during testimony. I don't know if I'm in a position now to make a ruling at motion to limine stage. And so, but I've got your response now, and I'll continue to consider the argument there. All right. Any other matters, motions in limine to address? We've addressed the timing. I've got defense's response here.
The city indicated it was planning on raising more arguments regarding defense motion in limine 2. I didn't know if there was anything other than the warrants that the city was planning on introducing.
Ms. Pinkston, I didn't.
Yeah, that was
pick up
the only
anything.
thing that I wanted to discuss. I felt like it was similar to the prior medics, kind of went along with the warrant issue.
Yeah. The reason I ask is there was a discussion coming up with my interview of Officer Spithaler and in his report describing two purposes for contacting my client, one of which was to seek consent for a DNA sample to compare against the evidence collected at a suspected burglary on a different date. And I wasn't sure if the city was planning on bringing up that topic at all, and if so, whether there are limitations regarding that.
Okay. Ms. Pinkston, I guess I'll turn to you.
I've spoken to Officer Spithaler, and the direction I've given him is that really basics of simply, why did you want to speak with the defendant that night? We were investigating an ongoing investigation. I wanted to question him, and that's it. We won't be talking about the need for the DNA or any what the investigation was related to. Just they continually have ongoing investigations where they try to meet with people, get more information. That's all.
Okay. All right. And that, again, if I think preliminarily, I don't see any issue with that. I think that, again, if the testimony happens to get to a place where it's moving too specific, and Mr. Taylor, you're free to make an objection. But I think as far as, that, and again, I don't want to put too many constraints on direct here, but I think given that layout, it seems appropriate to me. Understanding that, Mr. Taylor, if you're free to make an objection if you feel it's moving into 404B territory.
Yes, Your Honor.
But that's helpful to clarify up front. Thank you. Any other matters?
The only other question I had for the court was, I understand that we're doing 2-day trials and we'll start this afternoon with selection. And I had inquired on Friday of court staff if they wondered if we only have one witness, will the court want to proceed today? I do have, it's just one law enforcement officer is all we have. He is on standby. He wouldn't be available until 2:33 because he's been working since 8 p.m. and he doesn't get off till 10 a.m. So he would be available, but probably not till 2:33. And so I just wanted to know if that was something the court wanted to do or what the court's schedule was.
2:30 today?
Yes.
Or tomorrow?
Today.
Okay. Yeah. So in this court, my experience has been that the most we get into as far as after, if a jury is selected, oftentimes, given that day 2 is typically not even an all-day event, then the jury is selected and then opening statements begin the following morning. And then the trial either, parties make their closing remarks before lunch and then the jury deliberates, or day 1 is used as the full trial. If sometimes though, if it is a bit of a likely to be a shorter trial and that there's, like in this case, one witness, opening statements sometimes happen the day before. So after the jury is selected, the attorneys make their opening statements, and that's usually as far as we go into day 1. And then day 2 begins with presentation of the case in chief. So my inclination would be that if the parties would like to at least get a head start on the trial itself, we could do opening statements this afternoon. But I think as far as having the officer testify, I think maybe it'd be safe to say that would be tomorrow.
Okay.
Yeah.
Correct. Thank you.
Okay.
And is selection at 1 or 1:30?
Selection begins at 1:30, isn't that right, Amy?
Yeah.
That's late.
All done with getting them all set up in the.
Yeah, like 1:30.
Yeah. Yeah. I think the jury, the panelists are here at 1, and then they get organized. I'm not sure how that process works. And then the parties, we'll meet back here at 1:30, and then we'll usually, just if there's any other remaining issues to address, and then we'll bring the panelist in at 2.
Okay.
Start. Okay. I believe we've got, let's see, last thing. And we can address jury instructions later. I've got defense has proposed jury instructions.
I'll have mine
Is this
ready
yeah,
for the court
okay.
after lunch.
Perfect. Okay. Any other matters from the city?
I don't think so. I think the only thing that I would want to touch base with Mr. Taylor about is what his expectation of where Mr. Cruz will be between now and then, since it's such a long gap.
Yeah.
So I'll do that off record.
Okay. All right. Mr. Taylor, anything on your end?
No, Your Honor.
All right. Okay, Mr. Cruz, we'll see you back this afternoon, sir.
Yes, Your Honor.
All right. Thank you.
All right. That one's going forward this afternoon. Preliminaries out of the way. Lots of short little cases. Let's head back to Judge Webster. Oops, sorry.
On the issue of disposition pursuant to plea negotiations, the state has recommended a $300 fine, the minimum required by law. That the court impose appropriate court costs and attorney's fees, if any. State would further recommend a suspended jail sentence of 120 days, subject to a non-reporting probation of 6 months.
Mr. Patterson, anything further? You're muted, Mr. Patterson.
Nothing further, Your Honor.
All right. Where do you work, Mr. Topham? Or
I work
Tom?
in a Brahms warehouse in Tuttle of Oklahoma.
What do they pay you per month?
It's $19.50.
An hour or a month?
Oh, my bad. An hour. Yes, sorry about that.
You know what that computes to per month approximately?
With overtime, I make roughly $6,000 a month.
Yeah, probably not going to qualify.
Right. Okay, sir, you're going to have a $300 fine and $108 in court costs, plus $250 in attorney fees. I'm surprised you were able to get a court-appointed attorney fee at those wages, but maybe they've gone up. So your total due will be
Or maybe you told them something differently.
$658 approximately. Your jail sentence is 120 days, but you won't have to serve that if you successfully complete a 6-month non-reporting probation. You will not have to see a probation officer, but you are on probation for 6 months. If you violate it, it can be revoked and you can serve 120 days in jail. If you don't want to violate it, you need to follow these conditions. 1, violate no laws for 6 months. 2, pay the $658. And how much time do you need to pay that?
I can pay that all this Friday, ma'am.
I'm going to give you 30 days in case we don't have the journal entry done by then.
Yes,
But to find the website, call the clerk at 316. Can you write that down?
Yes, 316-32.
867-5309.
437.
435-678. 867-5309. There we go.
And those will be the 2 conditions with which you have to comply to avoid doing jail time. Any questions about any of that?
No, Your Honor.
All right. Anything else from counsel?
Not from the state, Your Honor.
Nothing further, Judge.
And Mr. Topon is excused. You may go, but don't forget your conditions.
Yes, ma'am. Thank you.
You're welcome. We'll now be on the record in both BU 2024 TR 745 and 2025 TR 2069, each captioned State of Kansas versus Vanessa B. Young. Jared Regier for the state, Darren Patterson for the defendant, Vanessa Young, who appears in person and pro se. Mr. Patterson, announcements, if any?
Mr. Aguirre, what's requested, is that acceptable?
Your Honor, the state's information is that the state has recently communicated with counsel for the defense via email in this matter.
And are you ready to proceed, Mr. Regier, or does that depend on the defendant's response to your email, maybe?
Ready to proceed, Judge.
Very well. Please make announcements, counsel.
Your Honor, in this case, I would announce this time that in both cases on the driving while suspended charge, state has agreed to amend to KSA 8235, no valid driver's license. My client would enter pleas of guilty in both cases to those amended charges. State has agreed to dismiss count 2 and 24 TR 745.
And in the 2069, there is no other charge.
Right. So it'd be basically 2 counts, no valid driver's license, 1 in each case.
Okay. Miss Young, let's take a look at that. I understand, Mr. Regier, that is your agreement.
The state's understanding is that upon successful entry of a plea to amended counts 1 in both cases to no valid driver's license under KSA 8235, a Class B misdemeanor, the state is prepared to dismiss count 2 in the 2024 case. Recently, counsel for the defense has brought additional information to my office's attention, which is the basis of this negotiated plea offer.
Very well. Miss Young, we're going to look at BU 2024-745. That's a case in which count 1 reads no driver's license. It now reads no driver's license in possession or no valid driver's license, period. Let me see if I get that right. 8235, driving without license, period, right? No valid driver's license.
Correct, Judge.
That is the state's understanding, not an amendment to 8244, no driver's license in possession, which is an unclassified misdemeanor.
Right. All right. So, Miss Young, how do you plead? This is the case that had 2 charges, and they're going to dismiss the insurance per plea agreement. But how do you plead to the amended count of driving without a valid license in Butler County on March 15th of 24?
Guilty.
And are you pleading guilty because you believe you were, in fact, driving on a highway or roadway open to the public without a valid license?
Yes, Your Honor.
And that was in Butler County, March 15th of 24. Is that right?
Yes, Your Honor.
Now let's look at the other case, BU 25 TR 2069. How do you plead to the sole count as amended to driving without a valid license in Butler County on August 23rd of 2025?
Guilty, Your Honor.
Are you pleading guilty in each of these cases because you believe you were driving without a valid license on the days alleged, in this case particularly August 23rd to 25?
Correct, Your Honor.
And in both cases, you were driving inside of Butler County without this license?
Correct.
Anyone making you enter these pleas today by any threats or promises other than the plea agreement?
No, Your Honor.
Do you understand that in both these cases, with these pleas, you're giving up your right to trial, you will be found guilty and unable to appeal your convictions?
Yes, Your Honor.
All right. I find the defendant has knowingly and voluntarily entered her plea in each case to the amended count of driving without a valid license, finding the defendant guilty of violation of KSA 8235 in each count or case. Mr. Regier, recommendations for sentencing?
Your Honor, is the court finding that count 2 in 24 TR 0745 is dismissed pursuant to plea negotiations?
Court does so find.
Thank you, Your Honor. In both counts, the state is recommending that the court imposed a $200 fine, $400 in time fine total, that the court impose appropriate court costs and determine appropriate attorney's fees in each case. The state is further recommending 6-month underlying sentences in both cases, subject to a year of reporting probation in both cases, all standard conditions, including a $60 probation fee. The state will be requesting the court make an appropriate ruling as to whether or not these cases should run concurrent or consecutive. State's information is that in the 2024 case, the alleged occurrence date was March 15th, 2024, and that there was a first hearing in that case in June of 2025, or at least there was one scheduled, at which time the defendant failed to appear before appearing subsequently in September of 2025. And in the information in the 2025 case, it alleges an occurrence date of August 23rd, 2025 between the failure to appear and the first successful appearance in the 2024 case. So this, while the state
That was
does
a
not make
mouthful.
recommendations as to the issue of concurrent or consecutive sentencing per se, the state is moving the court to make an appropriate ruling based off of the procedural history of these two cases.
It's his first day back. Got to
Very
give
well,
him a
Mr.
minute to
Patterson, anything
download all the
before
updates.
sentencing?
On that last issue, Judge, I would just state that on the no valid driver's licenses, if I don't think this is going to happen, I don't want it to happen, but if the worst comes to worst, it seems that 6 months in jail should be sufficient to drive home the issue of not driving without a valid license.
Thank you. All right, Ms. Young, where do you work?
Public storage.
Public storage. What do they pay you per month to do that?
I'm not sure per month, but I get paid $10.30 an hour.
Married or single?
Divorced.
Minor
That would be single.
children?
I have 2 that are minors and a son that is 18. He graduates this month.
All right, on both of these cases, I should say each of these cases, I will waive the attorney fees. But you will be ordered on each to pay a $200 fine for a total of $400 between the two cases. Your court costs will be $108 on each case, and your supervision fee will be $60 on each case. So on each case, you have $368. I'm going to give you a 6-month jail sentence on each case. I'm going to run them consecutively so that if you violate your probation that I'm going to give you, you will serve a year. That is 6 months for each case. But if you don't want to serve any time, then make sure that you serve and successfully complete a 1-year reporting probation. While the sentences will be consecutive, the probation will be concurrent. And the probation conditions will include all standard, and probation will go over those with you. I'm going to order that you pay your costs and fees at the rate of 1/12 per month, 1/12 of the total balance on each case per month, starting with the 4th day of June, the 4th day of June, and then you'll have a 12th due on the same day of each month thereafter. Call the probation office after lunch at 316-322-4.
8675309. I like all the car talk in chat. I've been looking at a couple of the models you're talking
They may come back
about.
at 2. I don't know what time their lunch break ends, but it's your responsibility to call them today and make contact with the live person after court today
A living, breathing
and
person.
get started. Now, do you live inside of Kansas?
Yes, I live in Wichita.
All right, they can supervise that or transfer that probation supervision to Sedgwick County where you live, if that can be accomplished and if that would benefit you, if you would like to do that.
Yes.
All right, anything else, Mr. Regier, Mr. Patterson?
Nothing further.
Thank you, Your Honor.
Mr. Patterson?
Nothing further.
All right, did I give you their probation number? I did, didn't I, Miss Young?
You did.
Yes.
All right, thank you. You may go at this time.
Thank you.
You're welcome. I am through with my docket, but there's still a Rick Shear, whose name I think I called several times, maybe.
Hello, Rick. Last one before
Yes,
we go to
ma'am.
lunch. What do you think?
All right. Back on the record in BU 2025 TR 2660, State of Kansas versus Richard Ned Shearer III. Jared Regier appearing again for the state. Darren Patterson again for the defendant. Mr. Shearer, where were you when I called your name previously?
In the bathroom.
I don't know how to work this phone. I just previously got it and everything else, and yeah, I'm sorry about that.
Okay, you're here on 1 count of violation of ignition interlock device. Mr. Patterson, have you had a chance to talk to your client?
Yes, Judge, I just would inquire, Mr. Regier, is what's requested acceptable?
Mr. Regier, does the state wish to proceed?
Your Honor, I have a brief breakout room with counsel for the defense?
Jennifer, could you please put counsel in a breakout room?
Might be an offer on the table. Regier is feeling generous, where there's a flaw in his code. Excellent.
Jennifer, if you could, please put Darren Patterson and Jared Regier in a breakout room.
Now it's just you and the defendant, Judge. Do you want to have a little talkie-talkie? Sua sponte ex parte? Of course, after this, then if the offer has been put on the table, you're going to need to have the defense attorney talk to the defendant as well to present that to the defendant. No need to transfer. It's a good deal.
And Judge, if I could have a very brief breakout room with my client, there's just one small issue to make sure we're on the same page.
All right. Jennifer, would you please put Rick Shearer and Darren Patterson in a breakout room?
Everybody but the judge now knows what's being talked about.
Let's see, Jennifer, our afternoon docket is the language interpreter docket.
No, Your Honor, today is Monday. We do not have an
Oh,
afternoon.
that's right.
No afternoon dockets on Monday.
Thank
We only
you.
work half
That
days
means
on
it's
Monday, Judge.
Greenwood County afternoon. Thank you.
Yes.
Got my Butler County dockets mixed.
It's been a long day.
Yeah. But that means it'll be Wednesday then. We have the interpreter docket. All right, back on the record in 25 TR 2660, State versus Richard Ned Shear III, all parties as before. Mr. Patterson, any announcements?
Your Honor, when asked this time, Mr. Shearer will be entering a plea of guilty to the sole charge, circumvention of ignition interlock.
Bypassed ignition interlock. Judge, how do you feel about that? Good, bad, indifferent?
Mr. Shear, how do you plead to count one that alleges November 21st to 25 in Butler County, you operated a motor vehicle with an ignition interlock device with a vehicle without, let me read that again. On or about the 21st day of November 2025 in Butler County, Kansas, you did then and there unlawfully operate a motor vehicle not equipped with an ignition interlock device during your restricted period. How do you plead to violating the circumvention of an ignition interlock device?
Guilty.
By pleading guilty, you're admitting you did the act giving rise to this charge?
Correct.
And in your own words, what'd you do?
I operated a vehicle without the interlock device.
And you are required to do this as a restriction on your license?
Yep.
Yes, ma'am.
And this was November 21st to 25?
Correct.
And where were you when the officer observed you?
By Walmart and Casey's in El Dorado.
There's always a Walmart.
If the officer indicated near West Central and
In front of
Happy
the
Hill, would that
Walmart.
be right?
Yes, ma'am.
All right. And you're driving a white GMC Sierra with a black bed topper?
Yes, ma'am.
All right. I find you guilty as charged that you've knowingly and voluntarily entered this plea of guilty. Recommendations for sentencing counsel.
Yes, Your Honor. Pursuant to plea negotiations, the state is recommending a $200 fine, that the court impose appropriate court costs and determine attorney's fees. The state is further recommending a suspended jail sentence of 6 months, subject to a year of reporting probation, all standard conditions, including a $6 probation fee, and any other orders the court may deem appropriate.
Mr. Patterson, anything further?
Nothing further, Judge.
Mr. Shear, where do you work?
I'm self-employed. I subcontract.
And what do you make per month doing that on average?
It kind of varies, but I'd say on a rough average, monthly, it could be 2,200 to maybe 4,200, give or take. Just kind of vary.
You said you're self-employed. Is that before or after you take out your expenses for operating the business? Is that your take home?
Yes, ma'am. After.
Okay. All right. At this time, your attorney fees are $250, fine $200, court costs $108, and supervision fee of $60. Looks like that's about $618. How much time would you need to pay that?
Would 6 months be able to?
6.
That'd be fine. All right. I'm going to give you a 6-month jail sentence, but I'm going to suspend that. You will not have to serve that as long as you successfully complete a 1-year reporting probation. You need to call probation as soon as they open for lunch or from lunch. Their number is 316-867-5309. 5309. And all standard conditions will apply. They will go over those with you. You must pay the total due within 6 months. And you'll need to make equal payments. I think that's about $302 a month, starting with June 4th of 2026. 303. No, 203. Well, I did that wrong. How about 103? Is that right now, gentlemen? Did I get my math right? 103. 1/6 per month, anyway, starting 30 days from today, and then due on the 4th day of each month after. Anything else we need to address, counsel?
Your Honor, just to be clear, for purposes of the journal entry, is the court ordering the first monthly payment be made on by June 4th?
Well, today is, the first, May 4th, I'm saying, I'm trying to get this done. Yes, June 4th, 2026, 1/6 will be due of the total, and then on the 4th day of each month thereafter until paid in full.
Nothing further from the state, Your Honor.
Thank you. And if you can get that right in the journal entry, I think we'd all benefit from it. Appreciate it. Anything further, Mr. Patterson?
Nothing further, Judge.
Anything, Mr. Shear, before I let you go to call your probation after lunch?
No, ma'am.
All right. Thank you. Don't violate, or you could get your probation revoked and have to serve your jail time.
You don't want to do that.
You may go.
Thank you.
Then, you're welcome. I don't show anybody else on here, Mr. Baca. Have you anyone else?
I don't believe there's anyone that I have.
Okay. Mr. Regier, anyone else that you're aware of?
Nothing further from the state, Your
Judge,
Honor.
I'm done too, as a matter of fact.
All right. If Mr. Patterson and Jennifer have no one else, this matter is adjourned. Thank you all for your time.
We'll see you, Judge. Thank you very much. All right, it is lunchtime. We're going to go to lunch, and we're trying to find a case. We've got some other stuff in the works. I know there's that strangulation case that's going to be super short.
Procedural matters, and unfortunately you have not.
We'll see. We'll see where we go. Judge Boyd this afternoon, she's going to tell us if that case is on or not. We also have jury selection up in Thurston for that trial. The impeding officer in official business or something like that. So we've got a couple things. Double murder, impeding an officer, obstructing an officer, I think it was. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe to go live again after lunch, which appears to me like it's ham and cheese sandwiches with Dots pretzels, and I've got dill pickles on here, so I'm excited. Hope you're all having a wonderful Monday. We'll be back here after lunch because I'm making a portal. That's how we know. Alrighty. It is 1:30 right now. We're going to come back at 2:30. That gives us an hour. Gives Judge about half an hour to make a decision in her court, Judge Boyd's court, and then we'll see what we can do until Thurston happens. So, thank y'all. We'll see you guys in a little bit. Let me just finish building the portal so nobody gets lost on the hop. There it is. It's all there. All right, we'll see you guys after lunch. Have a wonderful one. See ya.